p.m. and she'll be with us, I think, most of the time throughout the conference. So she just sent the apologies, she was unable to make it this morning, but she'll be with us. So thank you so much to everyone, and I wish you all successful deliberations.
Thank you so much, Lloyd. I am going to be behind the podium now. As I was told that my back was facing the Zoom participants, so I do want to apologize to our Zoom participants for that. Before we conclude our introductory session, I have the enormous honor and privilege of inviting the Honorable Dr. Lumbu to also now address us just on some opening remarks. So if I could please hand over to him. And I would just like to remind everyone that if you require translation services, please put on your headphones and change to channel 1 for English, channel 2 for French.
Merci beaucoup. Je vais donc m'exprimer en français tout en souhaitant à chacun d'entre vous la bienvenue à cette conférence importante sur la mise en œuvre de l'impact et l'impact national des décisions de notre institution, la Commission africaine des droits de l'homme et des peuples. Madame la professeure Elsa Beshkouman, doyen de la faculté de droit de l'Université de Pretoria, Monsieur Lloyd Gouveia, directeur adjoint du Centre des droits de l'homme, et tous les participants ici présents, vos titres et qualités respectifs, différents distingués invités, mesdames et messieurs. Je voudrais avant toute chose saisir cette occasion pour vous transmettre les sincères salutations de mes collègues commissaires, membres de la Commission africaine des droits de l'homme et des peuples. Je suis très ravi, je le disais tout à l'heure à Madame la doyenne, d'être parmi vous ce matin. Je n'ai pas hésité un seul instant à supprimer les autres éléments de mon agenda pour pouvoir me joindre à vous, parce que les questions qui vont être discutées ce matin paraissent des questions de très grande importance au niveau de la Commission africaine des droits de l'homme et des peuples. Pour ceux qui ont coutume, habitude de participer au sommet de l'Union, à la conférence de l'Union, l'institution, l'organe fêtière de notre organe continental, l'Union africaine, et qui suivent les rapports que présentent régulièrement les organes judiciaires et quasi-judiciaires, je cite la Cour africaine des droits de l'homme et des peuples, la Commission africaine, le Comité africain des experts sur le droit et le bien-être des enfants. Nous partageons en commun une faiblesse congénitale. Cette faiblesse, c'est la mise en œuvre de décisions. Nos décisions ne sont pas exécutées. Et lorsque vous regardez, pour peu qu'il existe des études à cet égard, le taux de mise en œuvre d'exécution de nos décisions, il ne dépasse pas les 5%. Pourquoi alors avoir ce genre d'institutions créées par les États eux-mêmes? Lorsqu'arrive le moment de mettre en œuvre les décisions, les États sont inscrits aux abonnés absents. Je ne veux pas lire un discours de manière classique, parce que le discours, on en lit presque tous les jours, quand bien même le secrétariat m'en a préparé un. Tout à l'heure, le directeur qui m'a précédé ici a bien indiqué que nous ne sommes pas à une première rencontre. Il s'agit d'une troisième rencontre. Les autres rencontres ayant eu lieu à Dakar, à Zanzibar. Nous voici aujourd'hui à Pretoria. Peut-être que ce sera une occasion pour cette conférence de passer en revue également les principales recommandations de ces deux précédentes conférences et de baliser les chemins pour l'avenir. La Commission, comme je l'ai dit, connaît un sérieux problème. C'est un problème de taille, la mise en œuvre de ces décisions. Les diverses stratégies qui ont été mises en place, les diverses stratégies de suivi mises en place pour suivre la mise en œuvre de cette décision figurent bien évidemment au règlement intérieur, celui de 2010 et celui de 2020. Parmi ces stratégies, vous remarquerez qu'on a institué le mécanisme des commissaires rapporteurs pour pouvoir être le relais, faire le dialogue avec les États et les inviter à appliquer les décisions. À l'occasion de l'examen périodique des États, le jeu de questions-réponses, les dialogues que nous avons avec les États, nous ne manquons pas non plus d'inviter les États à appliquer les décisions que nous avons prises. Au cours de nos missions de promotion, nous faisons exactement le même travail en interpellant les autorités gouvernementales sur la nécessité qu'il y a à mettre en œuvre des décisions. Ou même au cours des réunions parallèles que nous avons, chaque fois que nous rencontrons les délégués des États, les membres du COREP, au niveau de Addis Abeba, nous ne manquons pas d'appliquer toutes ces stratégies. Mais malheureusement, nous ne sommes pas satisfaits des résultats à cet égard. Nous avions espéré que la mise sur pied dernièrement, parce que c'est un sous-organe qui est récent, du sous-comité du COREP sur les questions liées aux droits de l'homme, nous offrirait des leviers, des opportunités qui pourraient permettre de s'engager directement avec les ambassadeurs et permettre ainsi de faire appliquer nos décisions. Je peux vous avouer que nous n'avons pas encore poursuivi cette piste de manière adéquate pour savoir que si ce n'est pas finalement ça la solution. C'est la raison pour laquelle aujourd'hui, nous, en tant qu'acteurs de terrain, la société civile que je remercie ici, Open Society et les autres pour le financement, pour l'organisation, notre partenaire de tous les jours, le Centre for Human Rights de l'Université de Pretoria, nous mettent encore ensemble pour que nous puissions réfléchir en ayant un regard sur le passé, Zanzibar, Dakar, en prenant le dynamisme qui va naître aujourd'hui au niveau de cette rencontre de Pretoria pour qu'ensemble nous puissions aller de l'avant. Je ferai un rapport à mon retour. Nous avons une session ordinaire à Arusha à partir du 20 octobre. J'ai l'obligation de faire le rapport de ce qui sera dit ici. En tout cas, je ferai un rapport à tous les commissaires pour leur dire voici les différentes réflexions, voici les différentes recommandations que le Centre de Pretoria et les partenaires de la société civile mettent à notre disposition pour que cela puisse nous aider à aller de l'avant. Ça sera non seulement un rapport pour le commissaire, mais le monde entier va écouter ce jour-là lorsque nous allons faire ce rapport. C'est un rapport public, les différentes voies que nous proposons. Les États seront là, ils écouteront que ça fait 3 fois que nous nous réunissons pour qu'ils nous aident et nous les appelons simplement à une bonne volonté quant à cette question de mise en œuvre des décisions de la Commission africaine des droits de l'homme et des peuples. Permettez-moi de conclure alors en saluant l'engagement intermécanisme qui a eu lieu, qui aura lieu au cours de cette conférence. Il ne peut qu'aboutir à un système africain des droits de l'homme plus fort, beaucoup plus fort et beaucoup plus efficace. La construction de l'Afrique que nous voulons, cette Afrique que nous voulons, conformément à l'agenda 2063, ne peut se faire que sur base d'un agenda des droits de l'homme respectueux de cette question de la mise en œuvre des décisions. Et cela ne peut se faire que si toutes les parties prenantes, en ce compris vous, nos partenaires de tous les jours, qui nous aidez à réfléchir, vous qui nous assistez dans beaucoup de nos compétences conformément à l'article 45, si toutes les parties prenantes en font une priorité. Et je crois que nous réunir déjà ce matin, c'est une preuve intangible que vous en faites aussi une priorité. Je souhaite, avant de clore mon propos, vous remercier sincèrement de l'urgence que vous avez pu ressentir en organisant cette conférence. Et je voudrais euh, également exprimer ces remerciements pour l'attention que vous m'avez accordée tout à l'heure lorsque j'ai commencé ce discours. Je souhaite à nous tous de fructueuses délibérations et j'espère qu'à l'issue de ces rencontres, ensemble, nous allons rafraîchir les recommandations anciennes, en créer de nouvelles et oser aller de l'avant pour qu'un jour nous disions que si on n'a pas pu appliquer complètement les recommandations de Dakar ou celles de Zanzibar, c'est la rencontre de Pretoria qui a été un tournant décisif parce que depuis qu'on a eu cette rencontre, voilà maintenant les décisions sont en train d'être appliquées. Je dis et je vous remercie. Je nous souhaite à tous de fructueuses délibérations. Merci beaucoup.
Thank you so much for that address, Dr. Lumbu. We appreciate your presence here today, and we appreciate your words of encouragement as well. I would now like to call Mr. Poloshu Adegalu, who will be addressing us on the Center for Human Rights Annual Conference on Implementation of Decisions on African Human Rights Bodies. Poloshu is the leader, in the sense, of our litigation and implementation unit, and I will now be handing over to him.
Thank you, Tamika. Good morning, everyone, and welcome once again. I know you have been welcomed by the Dean and Lloyd, but I would also like to add my voice to that to officially welcome you as well to the. Is everything fine? Okay. Simpere? Oh, okay. I think that's some situation beyond our control, so we just have to make do. Just to quickly speak to the idea of the implementation conference and what we would really be expecting from this conference. I would start by saying that the implementation conference, broadly speaking, is part of the effort of the Center for Human Rights in improving the influence of the jurisprudence of African human rights bodies. And in terms of jurisprudence here, we mean the decisions of the African human rights body, their concluding observations and resolutions and other outputs from this body. The implementation conference, broadly speaking, falls under the broader project by the Center for Human Rights on strengthening national, regional, and continental human rights mechanisms and also promoting legal accountability mechanism. And as stated by Lloyd, this project is funded by the Open Society Foundation and more specifically, the Open Society Initiative for Southern Africa. So the implementation conference is one of the activities that we are doing under this project. And there are 3 other activities that we are also doing under the project. One of them is the capacity building and training for civil society organization on okay. Okay, we will quickly look into that as soon as possible. So the other activities, like I was saying, is CSO's engagement on with African human rights system, and we will be having the second edition of this program in October this year. And we also have the African human rights bodies case discussion series, which we have already have 4 series of this discussion, and the 5th edition of this series, luckily for us, will be part of the program that we will be part of the activities that we will be having during the implementation conference. Our final activity under this project is the declaration advocacy campaign on the ratification of the African Court Protocol and also the Article 34(6) declaration by African states. I think Lloyd has flashed this a bit to say that the Conference on Implementation of Decision of African Human Rights Body is really a 3-year project, and we are looking at all of the African human rights bodies, which is the African Commission on Human and People's Rights, the African Court on Human and People's Rights, and the African Committee of Experts on the Right and Welfare of the Child. So in terms of the choice of the African Commission as being the first body that we're having this year, it's actually a deliberate and strategic decision by the center to have the commission as the first body. So in April, 12th to 14th of April, 2023, early this year, the center and the RFK Foundation for Human Rights hosted an inter-mechanism dialogue between the African Commission on Human and People's Rights and the Inter-American Commission. And one of the issues, of course, that we discussed during the inter-mechanism dialogue is the issue of lack of implementation of decisions of the African Commission. And during this inter-mechanism dialogue, the different stakeholders that participated in that dialogue, including the center, did make a couple of commitments to address some of the issues and concerns that were raised during the dialogue. And this implementation conference is one of the activities that the center has flagged in April as part of its effort that it would, and part of the initiative that the center would take to ensure that some of the resolutions and decisions from the inter-mechanism dialogue did not just stay on the books. And I think references have been made to previous implementation conference, for example, in Zanzibar and in Dakar, and the need to ensure that the decisions and resolutions from these activities and conferences don't just stay in the book. In terms of immediate expectations from this conference, I think the immediate expectations are in 2 folds. The first expectation, of course, for us, because this is an academic conference, is that our presenters in the next 3 days, we get useful inputs from the delegates of the African Commission, including everyone in this room as well, to improve their paper presentations. And the presented papers will then be further developed based on the constructive dialogue that we will have in the next 3 days. And we will expect our participants to develop their papers and submit to us by 31st of October. We did receive a volume of application when we had our call for abstract and submission of paper. And in that regard, just for the benefits of our online participants who are not physically here because of budgetary constraint and the need to keep this event to 3 days, I would also just like to say that when we are at the publication phase, we will of course be extending the possibility of publication to a few selected applicants that are not currently here with us. The second expectation from this conference, which is immediate, is that the body, which is the focal point of our discussion for the next 3 days, the African Commission, will be able to highlight some of the efforts that have been made so far. And I see Honorable Lita is not yet in the room, but I think Honorable Lita will be speaking a bit to that. And also highlight some of the challenges, and hopefully, and most importantly, the Commission will gain valuable insight from the presentation and also act on some of the suggestions that will be made by our presenters in the next 3 days. And there's also the long-term expectation from this conference, which is the continuation of our institutional partnership between the Center for Human Rights and the African Commission. And I think most importantly, to ensure that we don't fall into the pitfalls of the past, which is the lack of taking on action points that have been discussed from conferences like this. So we do hope that we will be able to build on action points derived from this conference in concrete terms, in terms of our institutional partnership with the African Commission. I will just quickly take us through the program of events for the 3 days. We will be having this in terms of 5 panel sessions over the next 3 days. And each panelist will have for about 15 minutes to present their presentation. And after all of the panelists have made their presentation, so as you can see, there is this setup here that is empty at the moment. It's deliberate. When it's your turn to make your presentation, you all know the panel that you form a part of. You will all be there with the chair of the panel, and that is where our panelists will make their presentations from. The delegates of the African Commission, they are seated just towards you on this side. It's also deliberate so that when you make your presentation from there, they can give you their responses as the first respondent that we have had, that we have on the program. And we would just like to urge everyone to stick to time so that we are able to conclude each session as scheduled. And after all of our panel presentations, which will end on the first event on Friday, we will then have a second activity, which we have subsumed into the implementation conference. Like I mentioned in the beginning, the implementation conference is one of 4 activities that we are doing under this project with OSF on strengthening regional mechanism. So we will have the 5th edition of the case discussion series of the Center for Human Rights. And the case discussion series of the Center for Human Rights is a project that aims to put spotlight on some of the decisions of African human rights bodies. Like I mentioned, we've had 4 previous case discussion series on decisions of the African Court and decisions of the African Committee of Experts on the Right and Welfare of the Child. So the 5th edition will be focusing on 2 cases that we have selected from the African Commission. And for this case discussion series as well, we will have representative of the African Commission to give us perspective on some of the rationale for the decision in the case. And we will also have the applicant in some of the case, like Lloyd mentioned in his speech. We have Justice Masuku, who will be talking as an applicant in one of the cases that we have selected. And also in terms of evaluation, we will have someone from the academia who would give a critical evaluation of this decision to explain to us the jurisprudential contribution of this particular case that we will be discussing. I think that's broadly how we would have our events for the next 3 days. If there are other specific questions, please feel free to ask either myself or any of the member of the team, Tamika, Zena, Michael, and everyone here. I think there's been a lot of appreciation, so I would not go to that direction, but I would like to express my personal appreciation to Professor Franz Fiyun, who is not here with us for obvious reasons because he's on sabbatical in Canada, but he has really been very supportive and he has given us concrete suggestions in ensuring the realization of this conference. And I would also like to thank everyone on the team and also the communication team for their support. On this note, I would like to hand over to Tamika. Thank you.
Thank you so much for that, Felucio. Just before we go on, I just want to take this opportunity to just thank our translators and technicians for their services today. And that is Mr. Armand and Mr. Patrick, who are sitting at the back, and Mr. Shane Kirk as well for all their assistance for today and for bridging the gaps between our presentations and the participants that are here today. I think that their services were highly needed, and they have been really great in assisting us today. The next session that we have up is going to be, there is also a change in this part of the program as well. We will now be having Ms. Abiola Ido Ojo. I sincerely apologize if I am not pronouncing your name correctly, and who will be addressing us on the implementation framework of the decisions of the African Commission on Human and People's Rights. Thank you so much.
Thank you, Tamika. Um, Good morning, distinguished ladies and gentlemen, all protocols duly observed. I'll be standing in for Honorable Commissioner Lisa Musimi Ogana, who's held up in traffic. Just to give an overview of the implementation framework of the African Commission on Human and People's Rights to help set the scene for what we hope to be a very constructive conversation over the next couple of days. First, please allow me to add my voice to that of others who have gone before me to appreciate the organizers of this event and the various stakeholders who have contributed towards making the possibility of convening this event a reality. At the African Commission on Human and People's Rights, as our Honorable Chairperson rightly said, this is very important to us because we believe that the effectiveness of human rights protection lies in the implementation of the decisions of the Commission as well as various other human rights mechanisms, both within the African Union and the wider international human rights system, of which we are aware that this is a generic problem. So for us at the Commission, this is very important, and this is why we're here as much as possible in numbers at policy level as well as at technical level. We thank you very much for all those who are here, for making yourselves available to help to build on the efforts of the Commission over the years to be able to define an effective framework for ensuring the implementation of its decisions. Distinguished ladies and gentlemen, let me start by saying I believe that the Commission in itself needs no introduction. The mandate of the Commission is threefold in the list. It's to promote and protect human rights and to interpret the African Charter. But it can also be mandated to take on some responsibilities as vested on it by AU policy organs, and we've seen that manifest, especially in the context of human rights and peace and security. However, all of the work of the Commission results in outputs, as Olusho has already highlighted, decisions of communications, reports of promotion missions, resolutions that are adopted on various thematic and country matters, making recommendations, as well as a number of urgent appeals and interventions that are made from time to time in respect of emerging human rights situations. We have this in numbers, over 550 resolutions, over 90 promotion missions and fact-finding commissions, missions conducted up to date, over 130 state reports considered over the years with concluding observations issued, and over 819 communications with 181 decided on the merits. But the question that we're faced with is, what is the status of implementation? I'd like to say that the challenges that the Commission faces in respect of implementation of decisions is at least threefold. The first is that of is a political challenge. The second is a legal challenge. And the third is a structural challenge. My commissioner is here, so I will be stopping shortly. In terms of a political challenge, it is the issue of political will among member states to implement decisions of the Commission. The legal challenge is the perception of stakeholders, especially the member states who are the ultimate enforcers of human rights, ultimate guarantors of human rights, about the nature, the bindingness of the decisions of the Commission. And the third challenge over the years has been structural in terms of resources, human, material, and financial resources. On the legal challenge, we have had debates over the years about the bindingness or otherwise of the decisions of the Commission, rendered through all these various outputs that I mentioned, because of the quasi-judicial nature of the African Commission. And the Commission in this regard has consistently, at least over the past 20 years, insisted that based on the principle of pacta sunt servanda and the obligations of states under Article 1 of the African Charter to ensure that the rights guaranteed in the Charter are brought to life, its decisions are required to be implemented. On the issue of human, material, and other resource constraints, the Commission over the years has had an average of between 3 to 9 legal officers over the past 35 years or so of its existence. This, of course, raises an issue of the capacity of these numbers to oversee and to support at technical level the 11 commissioners in discharging their mandate of promoting and protecting the rights of African citizens in what now are 54 member states of the African Union. Having said this, distinguished colleagues, please let me hand the floor now over to Commissioner Letha Musimi Ogana. We will now give a highlight of the measures that the Commission has taken over the years and the current framework for overseeing the implementation of decisions that are issued through its various outputs. Thank you very much.
Thank you very much. Good morning, everyone. I've barely taken my breath. I'm sorry for coming in a little bit late. I apologize profusely. I'd forgotten Pretoria, that the traffic jam can help you not get there on time. But I'm here. That's the most important thing. I don't have the advantage of knowing everyone who is in the room. So I'll just start by acknowledging all the distinguished presenters and guests in the room. The Honorable Chairperson of the Commission, Honorable Lumbu, is with us. I recognize you. Our chair, scholars are in the house. I recognize the African Union Commission is represented, and all protocols observed. How much time do I have? Abiola has already taken some of helped to introduce my presentation. So how much time do I have? 20 minutes, okay. Thank you very much. So I want to start by saying that the Commission is the oldest organ of the African Union, adopted in Nairobi in 1981, over 35 years ago, and one of the oldest, actually the oldest treaty. It is the mother of all the treaties in the African Union, human rights, I mean. And 35 years is a long time, given birth to a lot of protocols. I'm sure this may have been covered earlier, but we are very proud of most of them, including the courts. The Maputo Protocol, the protocols that advance human rights in the continent. And it works also closely with the Charter, the Children's Charter, and the Kampala Convention. The Commission promotes, its main mandate is promote and protect human and people's rights through issues of decisions, recommendations, among other things. We are in the process of AU reforms. And I think the good news is that we think the Commission has retained its mandate of promotion and protection, something which we think is very important moving forward. In this respect of its mandate, the Commission issues decisions emanating from, among others, one, communications procedures, including provisional measures and amicable settlements. 2, states periodic reports, concluding observations. 3, missions reports from missions which are either fact-finding or promotional. D, special mechanisms, outputs, letters of urgent appeals, resolutions and press releases, declarations, among others. And I think we are very proactive on this. This morning, I was just looking at what's happening in Gambia. There is a lot of backlash on FGM, and we're quite spontaneous. We respond immediately. We don't wait. I have seen the chairperson also special communications on Libya. Last week we had the crisis, the problem in Libya. Last week we had the earthquake in Morocco. So it's quite spontaneous. We also have commissioners' activities, which we present at each ordinary public session, and the commission's activity reports. In terms of commission's decisions emanating from the above procedures and activities, mechanisms and reports, we overlap and work very closely with member states in the implementation. It is therefore worth noting that for over 35 years I talked about, there is evidence that the Commission has been on the ground. I just want to give a brief presentation, a brief outlook of the communications and a summary really of what has so far happened. We have managed to consider 138 state reports. This is an average of 3 per year. And they broke it down to 1 every 2 days. Resolutions, we've had 567 as of 2023. On soft laws, at least 33 straightforward instruments. Communications, we've received 817 so far. We finalized 632, 181 are on merit, and 191 pending. On activity reports to the Commission, we have so far covered 53. I think in terms of statistics, when you talk about statistics, we don't normally have time to reflect on the people behind the statistics. Every process that we do involves people, human beings, and so it's not a linear process. It is a process which involves back and forth, a very, very elaborate way in which the Commission operates. When we receive communications, there are 3 stages that communications may go through. First of all, at seizure, we write to the applicant, we engage them, and if they do not present enough reasons or they are not interested in following up the matter, under the provisions that are allowed, if the time expires for them to pursue the case, then that may not go to the next stage, that is admissibility. And so we have what we call strikeouts. Because of the workload, the amount of workload, some of the strikeouts we are doing, actually some of them are over 5 years old. Of course, we had COVID, and there was a bit of delayed, responses. But if 5 years, an applicant has not come back with more information that they have been given, they have passed the deadline that they're supposed to respond, then it goes to strikeout. If the applicant does indeed respond and provide evidence and within the time frame that is required, and we write to the government or the you know, the party that has to defend themselves and they respond, then we go to admissibility stage. At admissibility stage, we go through the process, we check if the application has fulfilled the important processes before we decide if the case is admissible, and if it is admissible, then we go to the merit stage. And it's at the merit stage, at the end of the merit stage, that we are able to come up with a decision. So that's just a summary of the process up front. So let me start by saying that the existing framework for the implementation of the Commission's decision steps, there are certain steps we follow, and I will try and start with the legal framework for the implementation of decisions emanating from the communication procedure. I have summarized that a little bit, but I just wanted to highlight provisional measures. With regard to provisional measures, the state party concerned is mandated to report back on the implementation of the provisional measures within 15 days of receipt. Amicable settlements, once reached between the parties and the Commission is satisfied that the requirements of the amicable settlements have been complied with, it prepares a decision which contains a brief statement on the facts and has descriptions of the settlement reached. The decision is sent to the parties and communicated to the Assembly. The Commission commitment of confirmation of settlement is regarded to as a decision requiring implementation and related follow-ups. Decision on merits. The Commission is required to communicate the decision to the state parties and the Assembly. The rapporteur for the commitment or any other member of the Commission designated for this purpose monitors the measures taken by the relevant state party to give effect to the Commission's decisions. Rule 125 of the Rules of Procedure 2020 outlines a very detailed procedure for monitoring implementation of decisions on the merits. Among others, parties inform the Commission in writing within 180 days from the date when the decision is transmitted to them of all action taken or being taken by the state party to implement the decision of the Commission. Additionally, the Commission may request a national or specialized human rights institution or specialized human rights body with affiliate status to inform it on any other action it has taken to monitor or facilitate the implementation of the Commission decisions. Further, the rapporteur may take make some contacts and take such actions as may be appropriate to fulfill his or her assignment, including recommendations for further action by the Commission as may be necessary. While the above discussion provides a legal basis for Commission to monitor its decisions with respect to communications, it is important to appreciate the practice by the Commission in following up, monitoring the implementation of decisions. With respect to a decision on provisional measures, the practice of the Commission is that where the respondent state fails to or refuses to implement the decision or on provisional measures, the Commission will often only wait for the party's submission on admissibility and proceed to make the decision based on facts presented. There is no follow-up on the state that is undertaken by the Commission. A decision on the merits requires follow-up within 180 days from the date when the decision was transmitted to the parties of all actions taken or being taken by the state parties to implement the decision of the Commission. In practice, the Commission awaits the state to inform it, and if the state does not inform the Commission, there would be no follow-up on implementation by the Commission. The reason the Commission awaits for state parties to inform it and does not follow up in the event the state decides not to inform it is due to the lack of human resources specifically dedicated for this purpose. In a bid to address this gap, focal persons, i.e. 2 legal officers, have been previously assigned to monitor the implementation of communication decisions on the merits. The extent of their monitoring is limited to sending an email or follow-up legal officers requesting updates from state parties on implementation of decisions on merit within 180 days from the date on which the decision was transmitted to the state party. Currently, it is clear that it's clear who are such focal persons within the Commission. I would just like now to look at Rule 125.7 of the Rules of Procedure, which mandates the Commission to, at each ordinary session, to report in public sitting on the implementation of its decisions. The Commission faithfully reports as required. Unfortunately, the Commission reports on implementation of its decisions is limited to feedback on implementation received, if at all, from state parties. Otherwise, the Commission has no aggressive strategy to follow up on implementation, nor does it have resources for that activity. I would like to quickly go to the legal framework for the implementation of the decisions emanating from state party reporting procedure. The Commission executes its protection and promotion mandate through the state party reporting procedure. The Commission considers state reports submitted to the state to it by state parties very seriously. Every 2 years pursuant to Article 62 of the Charter is a requirement, and any supplementary legal instruments entrusting the Commission with a supervision mandate. During the presentation of the state reports, the Commission dialogues with the state on matters arising from the report, including measures taken to implement the decisions. Here, I would like to say that, you know, it's a very interesting process, which I found myself very useful. Because number one, states, when the states submit their reports, all the commissioners look at the report and they ask questions. So all the mandates are able to look at the report, and in the asking of questions, the report is actually strengthened and comes back fuller and with more information. This is very useful because if it was not for that, nobody would imagine what would happen to, you know, mandates like indigenous people, because most of the reports don't even mention indigenous people in their report. Many of them would gloss over gender, and yet we have a whole protocol on Maputo. And so these questions that commissioners pose or raise once they read the report, strengthen the report so that when now the official report is submitted, you can see there's been evidence in terms of dialogue and also in exchanging, you know, seeking more clarification with regard to this. Now, on practical follow-up of decisions from the state party reports, reporting procedure, I will not talk much because it's in the presentation and because of time. So I'll go to the legal framework for implementation of decisions emanating from promotion activities, which is the third aspect. The Commission executes its protection and promotion mandate through promotional activities such as missions, which could either be fact-finding or simply promotional. Other promotional activities include seminars, conferences, and symposia such as this one. I was lucky to participate in a promotional camp fact-finding mission in Tanzania in the beginning of this year. And being my first promotional camp fact-finding mission, I found it very inclusive in terms of the way it is designed and the way the Commission engages not just with the state party, but also with other stakeholders, from government to human rights institutions, to non-governmental organizations, to indigenous organizations, and everybody is given an opportunity to participate. I asked them to take a beautiful photo at the Arusha Conference Center, where we were unable to go to one of the Maasai settlements in Loliando in north of Tanzania. And those communities actually came and they sat in the African courts room where we listened to their views. And I was telling them this is a beautiful example of how African Union tries to meet its people, because we had all these indigenous people. Now the translation was not English and French, it was Kiswahili and Maasai. And really, this was very, I felt very nice about that mission. We were able to meet literally everybody. The ones we couldn't reach came to us. On follow-up of implementation of decisions for promotional activities, while Article 83.2 of the Rules of Procedure limits the follow-up on implementation during promotion missions to decisions in state parties' reports, that is concluding observations. What happens is, in practice, is that the Commission follow-ups the implementation of the decisions from different procedures, activities, mechanisms, and reports. On legal framework for implementation decision emanating from special mechanisms, which is the fourth, pursuant to Article 30 and Article 45 of the Charter and Rule 125 of the Rules of Procedure 2020, the Commission protects and promotes human and people's rights through various special mechanisms, through the issuance of letters of appeals, press releases, resolutions, declarations, and any other soft law instruments. I just wanted to say that I don't know whether we'll have a chance to put on this, to share all the special mechanisms, but we literally have mechanisms which cover what you'd call traditional government sector, sectoral mandates. So we have from different mandates, freedom of expression, defenders of human rights, we have the indigenous people, we have protection of people living with HIV and AIDS, we have the Maputo Protocol, we have the social, cultural, we have the penalty, we have all these mandates. And so within that framework, commissioners are engaged and very actively on the ground. As you can be aware, letters of urgent appeals, press releases, and declarations seek to draw the attention of authorities of the particular state to the situation at hand, and while also requesting the state to take appropriate measures to redress the same, ensures non-repetition, as well as creates conducive environment for the exercise of rights and freedom guaranteed in the Charter. I could go and look at each of them, specifically the letters of appeal, press releases, but let me, because of time, go to the fifth legal framework for implementation of decisions emanating from the commission activity reports. And this is pursuant to Article 30 and 45 of the Charter through decisions emanating from individual commissioners' activity reports. Every member of the commission is required to submit a written report on activities undertaken in the period between two such sessions at the ordinary sessions. Normally, we have 2 open sessions and 2 private sessions. In the private sessions, we devote those to the commission's work. We look at all the communications in a closed session. But in the open session, which is open to public, which happen twice a year, one at the beginning of the year and the other one at the end of the year, we open the first part of the open session and we get to report, we have participants, stakeholders, and everybody. Commissioners, each commissioner during the first week of the open session presents their report to the public, what they have done inter-session, in meetings they have attended, letters of appeals they have issued, communications they have handled, and that information is given in public, and this gives stakeholders an idea of the work the commissioners do on a day-to-day basis. Remember, commissioners are not full-time. Commissioners are off, they are off headquarters. They work, they put energy from whatever space they're in. So over and above attending the statutory meetings, the sessions, the AU meetings, the summits and all that, and inter-sessional activities, they are able to find time to report back in their capacity as elected officials. With regard to a practical follow-up on implementation of decisions emanating from Commission's reports, practically follow-up on implementation of such decisions is supposed to be undertaken during the promotional missions. There is no deliberate follow-up on whether or not decisions in the Commission's activity reports have been implemented. It is not a continuous work, as in the case with concluding observations issued within the state parties reporting framework, which are followed up in subsequent state reports or within frameworks of promotion missions. Sixthly, the commission executes its protection and promotion mandates and other activities through the commission's activity reports, which is submitted by the chairperson or his representative to each ordinary session of the assembly. The commission is an organ of the African Union. And as an organ of African Union, one of its statutory role is to report back to the assembly. The Assembly of Heads of State meets twice, January session, which is a full session, and July session, which is now called the half-year, mid-year review session. Usually, organs in the AU report directly to the Assembly of Heads of States. The specialized agencies may report through their commissioners in Addis Ababa, but because our organ, the commission is an organ, it presents its report directly to the Assembly of Heads of States in January in Addis Ababa. Additionally, the commission also participates in other inter-organ processes. And I want to mention Agenda 2063 here. I don't know whether it has been mentioned before, but we are all working towards implementing Agenda 2063. So if you work in silo, we may not get to where we are going to. So we have a practice in the union where organs meet and we look at themes, joint themes. For example, the human rights cluster we operate under AGA, the African Governance Architecture, where human rights and good governance is clustered. And so we participate in inter-organ processes and meetings where by the time we go to the assembly, we get there speaking as one because we are all serving the same institution, we are all serving the AU. With regard to collaboration, I think I will just skip that because I've given an overview, but I want to mention two very important interfaces that we have. The Children's Court, the Children's Committee on Experts and Rights of the Welfare of the Child, and the African Court are two of our siblings institutions that we work very closely with. The children's rights specifically looks at the issues of children. And so any human rights issues that come from them is also a part of our business. The court is the other side of the commission in terms of our mandates. We have a complementarity within each other, and at the moment we have a roadmap where we have agreed on a joint framework of how we shall do things. At what stage do we pass on work to the court? At what stage does the court call us in? And so I just wanted to mention that before I say that there are challenges. I don't want to call them crises as it's called in this report. Challenges, I always say, because I've been an implementer in my entire life, if you do not implement anything, you don't face any challenge. It is only when you try to implement something, that's when you realize, oh, so this legal text does not fit the ground. And then you call that a challenge. Actually, you're supposed to use that knowledge, learn lessons, refine your work moving forward. So I look at challenges myself as a way of bringing back learned lessons into the process moving forward. There are proposals for a paradigm shift, and I think they're all well outlined. I will not go through them because I've already been given a time signal. But in conclusion, I wanted to say that the above decisions have highlighted the existing frameworks and what obtains in practice insofar as monitoring and implementation of Commission's decisions are concerned. We have done a critical analysis, which is in the document, of existing implementation frameworks and possible reasons for non-implementation. We propose a paradigm shift. It is also in the paper in form of a comprehensive implementation strategy with hope that it would resolve some of the implementation challenges and not crises. Our proposals are therefore meant to provide further discussion for your day-to-day. I want to thank you for your patience and to say that it has been my pleasure. This is the first time I'm participating in this particular forum. I am told it is the third in a row, and I will be looking forward to listening to the academic and intellectual contributions that will come out of here. And I hope that we will all learn and move forward with implementation of the decisions emanating from the Charter. I thank you.
Thank you so much to our two speakers, Ms. Abiola Ido-Oju, for stepping in at the beginning and for addressing us in the interim. And then also to our Honorable Dr. Lita Musiemi Ogana. We really appreciate your presence here, and we would like to officially welcome you to this conference as well. We are now going to take a short break. We are running a little bit over time. So if I can ask everyone, we want to take a group photograph so we can really capture this moment and everyone's presence and participation here. The group photograph will be taken outside. So once you leave the boardroom, there will be people to assist you and to direct you exactly where to go. So you will then take the group photograph. There's also some tea and coffee and a few snacks that has also been provided. Please, ladies and gentlemen, I really want to ask that we try to be as quick as possible so we can come back into the room. I know I know I'm being ambitious by requesting that everyone be back by 10:15, but please note that you can bring your coffee and your cup. I think that's very ambitious. We'll say, I think maybe 20 past. You can bring your coffee and teas and your snacks into the venue as well. So please do that in the interest of time. Thank you so much.
Yeah, 1, 2. One, two.
Everyone, if we can just start taking our seats and settling down so we can start as soon as possible. This is for everyone who is still enjoying their tea outside. I know you can hear me. Please make your way back in. Okay, everyone. Welcome back. Um, I know some of you really tried to be on time, so thank you to those that were back on time and came back as speedily as possible. So this morning, because we were running a little bit late, we didn't get a chance to do introductions, specifically of everyone that's in the room. And so we do want to do a very short session now where we can just go around the room and where everybody can introduce themselves very quickly and very shortly. So I will start and I will do a quick example of it. And then if we can start on that side of the room, which is the left-hand side, you will notice that everyone has mics on your table. You can just press the button that is down in the center. And if you speak into it, the mics will be operational. Okay, so as I did mention earlier, my name is Tamika Thambiran. I am at the Center for Human Rights, and I am a legal fellow with the Clooney Foundation for Justice. under the Waging Justice for Women project. And if we can start on that side of the room now.
Okay, my name is Dr. Victor Ayeni. I'm a senior lecturer in law from Adekunle Ajash University in Nigeria. I graduated also from the Center for Human Rights.
Good morning, everyone. My name is Clément P.B. Mavungu, legal counsel for the Pan-African Parliament. I'm representing Madame Lindy Kumalo, clerk of the Pan-African Parliament.
Good morning, everyone. My name is Patricia Mudhoni. I'm an advocate of the High Court of Kenya. Hello, everyone. My name is Kanyo Farize. I am the Deputy Regional Director for Research at Amnesty International.
Good morning, everyone. My name is Clara Burbano Herrera. I am a professor of rights at Kent University and director of the program for studies on human rights in context.
Good morning, everyone. My name is Beryl Orao. I work with the Kenya National Commission on Human Rights.
Good morning. My name is Lydia Winnie Kembarazi. I'm a Ugandan human rights lawyer and the advocacy officer at the Institute for Human Rights and Development in Africa, Banjul.
Good morning, everyone. My name is Deborah Nyokabi. I'm an advocate of the High Court of Kenya, as well as a program officer at the Network of African National Human Rights Institutions. It's a pleasure to be here and I look forward to the discussions.
My name is Henoka Shagri, Center for Human Rights.
I'm Ethel Fiato, working with the Center for Human Rights.
Good morning, everyone. I'm Dev Jyoti Ghosh. I'm an Indian human rights lawyer, currently a researcher at the Department of Sociology at the University of Pretoria. Thank you.
Good morning, everyone. My name is Neil Perma, and I'm a lecturer in law at Middlesex University, Mauritius.
Good morning, everyone. I'm Petrus Yungefele Nikauluma Hatupopi. I'm a legal associate in the Legal Council of the African Union.
Good morning, everyone. My name is Japheth Begon. I lead Amnesty International's advocacy engagements with the African Union, and I'm also an adjunct lecturer at the Center for Human Rights, University of Pretoria.
Good morning, everyone. My name is Ayalo Gitacho. I'm from the African Committee of Experts on the Rights and Welfare of the Child Secretariat, based in Marseille. Thank
you. Lloyd, I think we can start again from your side and just come around again.
Sorry, Lloyd Kuvea, Center for Human Rights. I'm Assistant Director there. Thank you very much.
My name is Jonathan Obogi. I am an advocate of the High Court of Kenya, a law lecturer and an associate of the Legal African Union.
Bonjour, je suis Serge Frédéric Mboumé Nzese. Je suis juriste principal à la Cour africaine des droits de l'homme en charge du suivi et de l'exécution des décisions judiciaires. Merci.
Morning, everyone. My name is Timina Olajuwon. I work with Muse Peace Foundation and also a postgraduate student at the University of Western Cape. Thank you.
Hi, everyone. My name is Esther Gumbo from the Nelson Mandela University. I'm a lecturer.
Good morning, everyone. My name is Pacharo Kaira. I'm from Malawi, Minister of Justice, Foreign Affairs, and presently I'm based in Geneva at the Malawi Mission. Thank you.
Good morning, everyone. I'm Chairman Okolo Ise, Nigerian by nationality. I've recently just rounded up my work as a senior legal expert at the African Commission on Human and People's Rights. I have research interests in the African human rights system. Thank you.
Morning, everybody. My name is Alam. I'm the Communication and Database Officer for the Commission.
Good morning, everyone. My name is Eunice Malota.
I am a legal officer with the commission and I am on secondment from the government of Botswana. And part of my assignments within the commission is on implementation of the decisions of the commission. Thank you very much.
Good morning, everyone. My name is Pedro Rosaco. I'm a senior legal officer at the African Commission on Human and People's Rights. I'm in charge of the management of the communications. Thank you.
Good morning, everyone. My name is Abiola Idowojo. I'm the acting executive secretary to the Commission, the African Commission on Human and People's Rights, where I've worked for cumulatively 12 years plus. I'm also an alumnus of the Center for Human Rights, the Masters in Human Rights and Democratization program, which I did 20 years ago, and during which I interrogated the question of implementation as far back as 20 years ago. I'm happy to be here. Thank you.
Good morning, everyone. I'm Lita Musimi Ogana. I think I'm the youngest commissioner in the commission, elected last year in July in Lusaka. But I'm not new to the African Union. I think I may be the oldest because before I was elected, I worked in the AU organs for almost 20 years. I think I was the only staff member who was able to work in the almost all the AU organs and specialized agencies, apart from the commission. So when I was elected, that circle was complete. Yeah, I started my career in the AU at the NEPAD Secretariat when it was new. Those of you remember NEPAD, the old days. We were the ones, a couple of us who were mandated by heads of state to convert the Yellow Book to reality. And then from there, I moved to the commission, AU Commission, where I was a director for women. I think you'd call it DG for women for almost 10 years. And so through that, I was able to overlap with all the AU organs. And I'm pleased to be here. And I think this is the first time I'm participating in this forum. And I hope I will learn from it. Thank you.
Bonjour de nouveau à tous les conférenciers. C'est le professeur Rémi Ngoy Lumbu, professeur à l'Université de Kinshasa. Mais je prends part à ces travaux à ma qualité de président de la Commission africaine des droits de l'homme et des peuples. Merci.
Good morning, everyone. My name is Dr. Tino Adehojo. I'm the head of Pan-African Women's Studies at the Institute of Pan-African Thought and Conversation, University of Johannesburg. I came, and this is my first time of participating here too. And yeah, I hope to learn from everybody. Thank you.
And last but not least, we have our brave frontiers at the front.
Good morning, all. I'm Fatima Mursala Aminu, a judge of the Federal High Court, Nigeria.
Good morning, colleagues. My name is Thomas Masugo. I'm a judge of the High Court of Namibia. I've served in Swaziland as a High Court judge and in Botswana as well. But I come in a special capacity as the victim in Communication 444 of 2013. Thank you.
Thank you so much for that, everyone, and for your participation. I think now that we know everyone just a little bit better and in what capacity and role they are attending this conference, it helps us just a little bit to get to know each other a bit better and to understand everybody's background. Our next session is our first panel session for the conference. So I just want to explain a little bit on how the panel sessions are going to work. So we have about 4 panelists. And we also have a chairperson, and the chairperson will essentially regulate the proceedings with the panelists. Each panelist will be doing a presentation of approximately 15 minutes, and they will be discussing various topics, which I will be introducing once we call each panel. So without further ado, I'd like to call the first panel session. And the topic of this panel session is the role of the African Commission on Human and People's Rights. The chair for this session is going to be Lloyd. And our panelists, and please, as I call you, if you would please make your way up to our panel, which is just on the left-hand side of the room, which I guess would be the right-hand side if you're facing the screen. So if Lloyd, if you could please assume your position as the chair. Also like to call Dr. Victor Ayeni, who will be presenting on the role of the African Commission in implementing its decisions. Justice Fadima Murtala Aminu, who will be presenting on harnessing technology for enhanced implementation, leveraging digital tools and platforms to promote compliance with the decisions of the African Commission on Human and People's Rights. Ms. Lydia Kembabazi, translating recommendations into justice, the role of the ACHPR in enhancing compliance with its decisions from individual communications. And Dr. Chairman Okoloese, why a special mechanism for monitoring implementation of decisions by the African Commission on Human and People's Rights is long overdue. For this panel session as well, we also have an ACHPR respondent, and that will be Ms. Abiola. So please could you join us in the panel session as well? Or you can remain seated there and you can address it from there. Okay, so Lloyd, I will be handing over to you. Yeah, sorry, just 1 second, Felucia would like to address.
Just to say that, so for all of our panelists sitting there, when it's your turn to make a presentation, you come here to make a presentation. Some of you have shared your slides with us. We will set that up for you and you can have your discussion. Then you go back to your seat after your presentation. And then after after everyone has made their presentation, that's when we'll have the respondent respond to everyone. And then you speak from that side and also address comments from the general house.
So I will be leaving the mic over here so that each of the panelists can do their presentations using their slides. And also, if you would like to just also, keep your earphones just ready in case, there may be any questions that may be in French and the translation services are needed. So yes, I'll be handing over now to the panel.
Thank you so much, Tamika. So there are 4 papers, excellent papers. It's heartwarming also to note that in the room, we have so many alumni from the Center for Human Rights. And also on this panel, we actually have 2 alumni from the Center. So Victor and Chairman are both alumni of the Center. So, and we are quite pleased to be chairing this particular session. I would have loved to start with Lydia because her paper sort of like sets the scene in terms of the role of the commission, what it is supposed to do. And then the other papers are a bit more focused on specific issues. But what I'm going to do, I'll call on Dr. Victor Ayeni, who has already introduced himself as a senior lecturer in Nigeria, but also just wanted to state as well that he has also written on state compliance. In fact, his PhD thesis was on state compliance of reparations of regional and sub-regional bodies. And he graduated from the center with an LLM in 2011. So without further ado, I'll hand over to you, Ayeni, because I think your paper, I love the way it focuses on dialogue and documentation as your sort of proposed tools to ensure or to enhance implementation of the decisions of the African Commission. Over to you, you have 15 minutes to present. Thank you.
Once again, good morning, everyone. The chairperson of the African Commission, distinguished commissioners here present, all the participants, I greet you. As was introduced, my name is Victor Ayeni. I graduated from the Center for Human Rights. I did my LLM here and also my PhD at the Center for Human Rights. But interestingly, my LLM dissertation and doctoral thesis are focused on the themes of implementation, impact, and compliance. After my doctorate, I've been privileged to have written 1 or 2 papers on the theme of implementation and implementation monitoring. So I'm going to summarize my views. Like the chairman said, the main crux of my presentation is to argue that the way forward for the African Commission is to look closely at dialogue and documentation over and above every other issue relating to implementation of its decisions. I started by looking at the goal. What's the goal? Why are we here? The first is to ensure that states report timely to the Commission, and also to ensure that they comply promptly, and most importantly, for states to become cooperative and enthusiastic compliance partner, a way that they could relate to the Commission without being forced to do so. But I say that unfortunately, that is not the case. States are not doing this. They don't report timely, they don't comply promptly, and they are not even cooperative at all. Even while they are cooperative, they are not enthusiastic about the cooperation. So the question is, how do we assist the Commission to achieve these 3 objectives that we have set before us? First, we should realize that non-implementation is a global problem. It is not peculiar to the African Commission. All international human rights institutions are struggling with the problem of non-implementation. The European Court of Human Rights, the Inter-American Court of Human Rights, even the UN Human Rights Committee are struggling. However, a major difference when we look at all international institutions dealing with human rights is, unlike all these institutions, one thing that I believe the Commission must work on with immediate effect right from this discussion is to have in place some form of data, however small, with reference to which stakeholders can relate the statistics that are available. So for example, when we say the rate of compliance is 5%, which case are we referring to? Which communication are we talking about? So then which remedial orders are we talking about? So it should be possible for us to have some form of data. The data we have currently are made available by maybe the academia or NGOs. I think it's good that the Commission should put in place a process where we translate these results from various studies into an official document for the Commission. The era of generalized statements like state do not comply with decisions of the Commission, which have been made by different bodies, I think that era should actually be gone. We should be able to speak to facts and to data. Okay, so what do we have for now? In 2007, Professor Franz Villon and Lirette Lowe published a paper which examined 44 merit decisions of the African Commission. And those decisions were made between the inception of the Commission and 2004. And what did they show? The results showed that the rate of full compliance was 14%, the rate of partial compliance was 32%, and non-compliance was 30%. How? What is the implication of this data? The first implication is that from 2005 to date, we really do not have any form of data in this form that tells us how states behave. And I think we can attempt to do it. It is a task that we can do. Even though we have some aspects that are missing, we can continue to fill in the gaps as the information are coming. We cannot wait forever. before we take such a step. So that would be my first challenge to all of us this morning, that we should replicate this data for all the cases of the African Commission. And I believe that is certainly doable. In 2021, my humble self and Professor Billion carried out a small in-depth case study analysis of 12 decisions of the African Commission involving 3 countries, Nigeria, the Gambia, and Zimbabwe. These are regular customers of the African Commission. Yes. So we looked at the cases, but the bigger question we were examining here is to check whether states tend to comply better with decisions of regional human rights bodies when compared with decisions of sub-regional human rights bodies. And we disproved that hypothesis, that there is nothing like that, that human rights compliance is dependent on a number of factors that we interrogated. But this is a snapshot of our findings from that study. As you can see, for full compliance in the 12 cases, we recorded only 18%, partial compliance 33%, and non-compliance on 48%, which is actually on the high side. So we can see that for example, the Gambia, there's 0 full compliance. So this is representative of what we see in most countries in relation to decisions of the African Commission. At the end of 2020, there's a report by the Working Group on Communications. At that time, the Commission had 147 merit decisions. We have just been told today there is now 181 merit decisions. And the Commission said then that only a handful of these have been implemented. So there is no question decisions of the African Commission are rarely implemented. I want to just introduce this point. The topic we are interrogating today has been interrogated by so many scholars for many years. And there are theoretical frameworks from which they have looked at this. I argue here that there are 3 main frameworks. The first one is what they call the rational choice theory, which basically says states uses cost-benefit analysis to decide whether they want to comply with a decision or they will not. The second one is constructivism, which argues that it is not cost-benefit analysis, rather it is the strength of persuasion and repeated interactions that causes this And the final one is a hybrid, which combines the rational choice theory and the constructivist theory. So there are a lot we can say here, but I think because of time, we need to move on. Now, from these 3 theoretical approaches, 2 pathways have been developed for compliance. And these are: 1, enforcement model, that if we want decisions of the Commission to be implemented, the first pathway is enforcement. The second pathway is the discursive model. And in Africa, the enforcement model it doesn't work. In fact, there's no point thinking about it. There's no point even dwelling on it. So, and that is the purpose of my discussion, that we should focus more on the discursive model, which focuses on persuasion, soft power, and repeated interactions. And different theory, Professor Howard Cole has argued in his theory of transnational legal process that it is actually the relationship with states that produce compliance. It's not the hardness of the decision or otherwise. So, okay, so from all of this, African scholars have carried out a number of studies, and what they have found is that if the Commission wants their decisions to be implemented, there are 3 factors the Commission must put into account. Number 1 is the nature of the order itself. Number 2 is the peculiarity of the state required to take the action. And number 3 is the degree of follow-up and monitoring by various actors, which includes, and most importantly, the Commission itself. So when you look at it, the discursive model addresses point A and C of these factors. And that is why I'm going to focus on it for my presentation. So I said, for the purpose of my presentation, my proposal is that if the Commission wants to take 2 steps that will have the most important impact on implementation, those steps will be dialogue and documentation. What is dialogue? Here, I define dialogue as a back and forth process of engaging diverse compliance actors at national, subnational, and supranational level with a view of sharing and obtaining information about implementation and possible challenges to implementation, listening to parties, cajoling and buying them over, and most importantly, this is the aspect I want to emphasize. Most importantly, reinforcing the merits of the decision in line with shared values in an atmosphere of mutual trust. Very important. So as we go forward in our dialogue, these are the guidelines, these are the things that should guide us, that we are reinforcing the merits, the arguments in our decision, the merits. And then we are saying this in the spirit of shared values, because there are things we share with the states. Even though we do not agree with how they behave, they want human rights to be protected one way or the other. So we have shared value, and then we should have mutual trust. We should trust state actors that they are going to act right. Okay, but why is dialogue important? I said number one is because of failure of enforcement, the ineffectiveness of political monitoring. If the commission thinks a messiah is coming to save the commission and ensure its decisions are implemented, recently in 2022, myself and Professor Andre Verstaden, in one of our papers, we argue that the prospect for political monitoring of decisions in Africa is very unlikely when you look at the way the various organs of the AU behave. So the focus should be on dialogue, NGO, CSO implementation, and the African Human Rights Bodies implementation. So the second point is dialogue is the Commission's unique advantage. The Commission is a quasi-judicial body for a very good reason. It is not a disadvantage. It's an advantage because it makes the Commission to be less constrained than the court. It also makes the Committee on the Rights and Welfare of the Child to be less constrained than the court. In other words, they can carry out a whole number of activities that the court cannot. And these are opportunities for interactions. So I argue here that it is actually a strength. The Commission, to its credit, has used dialogue more than any other human rights body in Africa. And of course, the constructive dialogue mechanism of the African Commission in relation to state party reporting process is actually has been praised in different quarters. The only problem there is the constructive dialogue has not been extended so much to implementation of its decisions. It is rarely extended. It is usually seen as an appendage. If there is time, let's discuss about the decisions, but let's take the human rights provisions first. I argue to the contrary, that a state that has refused to implement decisions of the Commission is like a debtor state. The state is owing the applicant, the state is owing the Commission. So I actually argue that the decisions of the Commission should be taken first, even before looking at other methods of compliance. So then the international law compliance theory also supports dialogue. Then dialogue has intrinsic value, and it should be differentiated from debate. Dialogue is not debate. The language of debate is often used. So I also mentioned some of the principles of dialogic engagement that the Commission should look into, but because of time, I chronicled here the approaches of the Commission from the beginning. You know, how the Commission has approached implementation of its decisions. You know, writing letters, thematic resolution, country-specific resolution, extraordinary session in relation to Nigeria, judicial referral, 2 implementation hearings in the Endorois case and the other case. Then the adjustment of the rules of procedure in 2010 and then 2020, then the expansion of the mandate of the working group on communications to cover implementation of decisions, holding of seminars, in the one in Dakar, the one in Zanzibar, and the one that we're having now, which of course the Commission has been actively involved in, limited use of state reporting process to monitor implementation, advocacy visits, and all of that. Now, we did an assessment of myself and Professor Verstaden of the effectiveness of the monitoring mechanism of the Commission. And we looked at that of the court and the committee. what we found is that out of a total of 34 points, the commission scored 13 points, representing 38%. The committee scored 11 points, representing 32%, and the court scored only 9 points. And the reason for this study, the reason for this result, we can see it here. So we looked at a number of factors, including whether the commission has a special rapporteur for monitoring, including whether the committee has an implementation, a compliance report, whether the report is online, whether the report is disseminated. We look at different issues to come up with the findings. So what are the shortcomings of what we have now? Number one, implementation hearing has not been consistent and there is no coherent approach. The last one, 2013. So in the last 10 years, nothing really. No guidelines for its conduct, and we don't have procedure for joint hearing or hearing in situ. There is this, and this is one of the reasons the commission does not have information. If implementation hearings are held promptly, I think information will be available. Number two, state reporting. There is limited time is allocated to implementation of decision during state reporting process. And I argue that at least 25% of the time given to the state should be devoted to monitoring implementation of decisions. Then many states do not submit reports. So that's also a problem. Then judicial referral, of course, that is, it's not been consistent, and we know the reason why it has not been consistent. Also, there is no criteria set by the commission for deciding whether a case should be referred or should not be referred. So that is also a problem. National implementation structure, very weak, and I argue that the commission should insist that every state should have effective national implementation structure. Documentation, this is that is really a serious problem, and I believe from this conference we should look into it, whatever it will take us. So what is the way forward? Just quickly to round off, the commission needs to adopt a guideline on the conduct of implementation hearing, very important, and the hearings should be held regularly and consistently. And CSOs need to come in here, because it is only with the support of CSOs that the commission will overcome its implementation funding challenges. So state reporting, more time needs to be allotted. At least 25% of the time should be about what have you done about our decision. Very important. Then I also argue that special mechanisms need to be put in place. Dr. Chairman is going to speak about this. There should be a special rapporteur that is specifically devoted to implementation of decision. The approach of making all commissioners rapporteur for communication, I humbly submit that that may not be a good way forward. We should have a specific person designated. That is what happens in the UN human rights system, and I think it is the best option for Africa. So there should be a working group as well, because the special rapporteur or the commissioner cannot do all the work. We should have a body of experts that will support that special rapporteur or the commissioner to do the work, and experts who will provide the technical assistance so that the work gets done. Then there should be a permanent implementation unit within the secretariat, comprising people that can start to put together the reports, and what they will do has to go beyond writing emails. They have to be able to generate the reports from the start, and should have knowledge of some of the things that they need to do, for example, for categorization of compliance and all of that. Then civil society, I mentioned that there's a lot they can do, a lot. For example, the Coalition for an Effective African Court has taken the lead in providing information on the implementation of judgments of the court. We should have similar coalition for the African Commission, a coalition for an effective implementation of decisions of the African Commission. National implementation infrastructure is very important. It should be broad-based, top-level interministerial human rights decision subcommittee. Here, I argue for a subcommittee that is focused on decision implementation. The general human rights implementation structure may not be enough to capture implementation of decision. Okay, then the commission needs to redefine its role in this whole dialogue process, not as that of a supervisor. The commission here is not a supervisor, but rather a facilitator of dialogue and a co-partner with states. And I believe the commission has been doing that very well. I want to conclude that the prospect of political monitoring of decisions of the African Commission is not very good and very unlikely, at least in the nearest future. Effective implementation therefore depends on CSO and the African Commission. Today, I have spoken about the role of the African Commission. I hope another opportunity will arise for me to speak on the role of the CSO. I thank you for your rapt attention. Thank you very much.
Thank you so much, Dr. Eni, for your insightful paper. It shall be interrogated firstly by Abiola's respondent, but also people in the room who I think maybe make suggestions. Thank you so much for keeping to 15 minutes. I just wanted also to confirm that what you said about the dialogue process, that even lawyers can engage in dialogue with the respondent state that has been sued. I think that we saw that happening in the case of Modise versus Botswana, and also the case of Zongo versus Burkina Faso. So I think, thank you so much for that suggestion on dialogue and documentation as a way forward, and all the other things that you've mentioned. I just want to now move over to the next speaker. I think when you talk about the AHRDA, it's one of those civil society organizations that have done so much work in terms of filing communications before the commission, but not just at the commission, but also the other human rights bodies like the committee, the ECOWAS Court of Justice. They've done so much. And to represent the AHRDA, but also appearing in a personal capacity to present a paper is Lydia Kambabazi, who is one of the legal human rights officers at AHRDA. Over to you. And I think I enjoyed also reading your paper. I hope people are also going to enjoy listening to it and interrogate it further and make suggestions to improve it. By the way, I've also been informed to let you know that after the conference, or during the conference, with the permission of the authors, their presentations are going to be shared with everybody with their permission. Thank you. Over to you, Lydia. You have 15 minutes.
Good morning. Good morning, everyone. I bring greetings, warm greetings from AHRDA family in Banjul. My discussion and my presentation is going to be very brief, but it's based on how the African Commission can enhance its implementation of decisions, and how they could translate into justice for the individuals who sought protection of the African Commission in the first place. My intervention has been shaped by implementation processes of the African Commission upon analyzing what has been achieved and what are the challenges that they have. And most writers and scholars, including Professor Murray, Professor Villion, have all stated that the Commission actually lacks strategic interventions and tools to ensure implementation and influence compliance of its decisions. So my intervention will be guided by that. It is noteworthy to note that the African Commission has actually and excellently put into place some procedures, despite having huge cases before it. And since its inception has handed over 600 individual communications. Thank you, Pedro, for that information. However, if you look for it, you will not find it on the official website of the African Commission. So I must note that whilst gains have been made to support its protective mandate, the impact of the decisions of the African Commission is seemingly crippling due to lack of an effective, strategic, and robust follow-up mechanism. And this coupled, of course, with the lack of political will by member states, awareness of some of these decisions and recommendations, lack of clarity, who is supposed to enforce what, all have gone to frustrate compliance with the Commission's decisions for individual communications. And yet we all know compliance with all court decisions, whether they are just recommendations, whether they are binding decisions, is what gives legitimacy to any function institution. To note though, the African Commission has put into place various mechanisms and specifically designed for follow-up purposes. It is noteworthy that much as these mechanisms have not been effectively utilized to enhance implementation, they've been, for example, the adoption of the 2020 procedure rules, and they have brought such clarity to the follow-up procedure as they are expressly outlined under Rule 125. It has also designed specifically follow-up procedures, and these mechanisms, if used effectively, can actually enhance the implementation of its decisions. That's why I actually insisted on using the word enhance, because I think the strategies are there, the initiatives are there, the tools are there. We just need to be very strategic and ensure that we are consistent with implementation and compliance of the decisions. The Commission has also taken significant steps to guide engagement processes and ensure implementation of decisions throughout its new rules of procedure. And they have provided a robust framework, including the designation of a rapporteur for each communication, 180 days feedback requirement, and mechanisms to address non-compliance could contribute to transparent and accountable process. All these provide a forum for us right now on ongoing dialogue and cooperation, and ultimately promoting protection and promotion of human rights in Africa. Seeking to strengthen its system and assess the status of implementation, the Commission also took initiative to organize seminars in Zanzibar and Dakar. And from those, there were various recommendations that were very commendable, and if implemented, could definitely enhance the implementation of its decisions. A significant result of the Zanzibar and Dakar seminars was to increase, for example, the visibility of case decisions. But yes, we see that some of these are not even available on the website unless you personally go to the Commission Secretariat and receive some of those key data and statistics. I'm just lucky to be based in Banjul, but if it's someone else who lives, for example, in Nairobi or out of the country and wants information, then we see that the seminar's recommendations purpose had been defeated. So my recommendations, therefore, will be based on just a few of the challenges that I've analyzed, but specifically looking at strategic internal and external challenges that the Commission faces. So we have to acknowledge, of course, that not one universal approach can be used to implement decisions effectively. Like the previous speaker mentioned, there are various strategies that can be put in place. However, it's also important and pertinent to consider various factors, including context of the country, nature of the violated rights, whether you need a diplomatic approach or a stronger enforcement measures. We have seen that coercive measures in Africa tend not to work from research. And so the recommendations I have made have been put in place upon assessing efforts that the African Commission has put in place, but also identifying key strategic interventions that could enhance the efficacy of the African Commission, considering the diverse external and internal challenges that the Commission faces. So number one, which is very key, and I call this the main entry door key that will open all doors for the rest of the implementations to be done, is creating an implementation unit within the Commission. Speakers coming on will definitely get into details, but I suggest and opine that an implementation unit within the Secretariat would go a long way in coordinating follow-up, in collecting information, but also it would be a good strategy for people who do not have access to information to have a focal point person. I suggest that maybe a rapporteur, special rapporteur, much as there's a working group on communications, could be put in place to do that specific role of ensuring that the implementation unit runs well, have information, accessible database, a focal point person who can handle and track implementation of decisions, but also have an oversight that is systemic to ensure that the implementation process is done and is going on well. I've also opined that we could categorize remedies in decision follow-up. There are some decisions that the African Commission has had, for example, CERAC versus Nigeria. It addressed a diverse range of rights, civil, social, economic, and political rights. And all these can be cross-cutting, guaranteed under the African Charter. So if there's consideration on what remedies we need to have, because one single decision can encompass a mix of different categories of remedies. So it suffices to note that categorizing these remedies enables systemic follow-up, whether it's lack of compliance, whether it's partial compliance or full compliance, because then the Commission can actually follow up the information on the compliance that has been done. Is it a legal reform? Did the Commission recommend a legal reform? Was it monetary compensation that has been done? Are they equitable remedies like land restoration or changes to practices, including maybe initiation of new government programs? It's very possible that one decision could have that, but all decisions could be put into categories to ensure that the systemic follow-up of these decisions. Also, the African Commission in its capacity could harness the affiliate status of human rights institutions. The human rights institutions, I'm glad there's a representative of the National Association of National Human Rights Institutions in Africa, and I'm sure they will put into place the recommendations and how they can work to do that. The rights and privileges associated with these, with obtaining affiliate status, of course, are not without corresponding responsibilities. They come with obligation to assist the African Commission to provide information at the domestic level, but also follow up. And also under Rule 125 provides that the Commission may request a national human rights institution for information of any action that has taken place to facilitate implementation of any of its decisions. The Kenya National Human Rights Commission was very key on behalf of the NDRS community to ensure sensitization, to ensure follow-up and have dialogue meetings like he has mentioned. Going to address the lack of information and about even existence of the status of the decision or even implementation progress, I believe that the African Commission is best placed in ensuring that they can follow up. Noting from their Dakar seminar, it was noted by Commissioner Rain Alapini that we would create an implementation database and strategy to systematically follow these decisions with NHRIs, NGOs, and other actors who assist in collection and publication of information. The African Commission also was to put up a communication strategy, which I can be advised, I'm not sure is in place yet, specifically to address those issues. This could be strategically in place to work with different media associations. It can work with different media houses, but also be able to communicate and put information that could be out there for providing information. The Commission could also consider guidelines for NHRIs or engaging any other organizations and any other stakeholders on how best they can improve and consider adopting and working a plan for dissemination of information and communication. As I conclude, I'm also looking at identifying key relevant agency and government institutions responsible for implementation. Taking inspiration from other mechanisms like that have specific authorities that identify and execute their own decisions, the African Commission can consider adopting a similar approach. When you look at the ECOWAS Community Court of Justice under Article 24 of the supplementary protocol, it provides that member states shall indicate a competent national authority responsible for implementing their decisions. And it's worth noting that some countries like Nigeria, Mali, Guinea, Burkina Faso, Ghana have all appointed the Minister of Justice, and Guinea-Conakry has identified the Chief Registrar of the Supreme Court, and Mali has the Minister of Foreign Affairs to do that, and the Supreme Court. So the African Commission could then work with governments and states to ensure that they have and identify key specific government institutions that can then follow up on that issue. The standard setting of role of the African Commission is premised, of course, on the mandate to formulate and lay down principles and guidelines relating to human rights and freedoms upon which African governments may base their legislations. So maybe considering Burundi, which has put in place a legislation for enforcement of African Commission decisions, that's one of the next discussions I'm going to have, adopting best practices from that the African Court has a coalition of the effective African Court, which is which IHRD is a member of and is very proactive in ensuring that the court's decisions, the court's guidelines are shared, they are disseminated, but also replicated for collective advocacy and impact. The Zanzibar seminar also unveiled good practices, including some countries that had prepared, they have prepared interministerial committees to report back and ensure implementation of their decisions of the African Commission. I believe that also the Inter-American Court system has a framework for guiding discussions related to that in terms of having implementation hearings. And I think that was a trailblazer that the African Commission had picked up. And I believe with like the Modise and Botswana case, it would be very good to bring back such initiatives and not have a intermittent discussions and monitorings and implementation hearings on the same. Dealing with a political will on the part of the state, of course, that's very it's a very tough discussion to have, but I believe that the African Commission can actually be a trailblazer. Can be advised, but we are yet to have one discussion or one report given to the AU for each conference and for each activity report. And this is an opportunity I think the African Commission can actively explore and have a trailblazer for all other states to know that this is an intervention that has been adopted by the African Commission. Also challenging the element of non-compliance due to non-binding consequences could be having regular and more consistent cases going to the African Court for consideration, since states really are obliged, not persuaded, to recognize rights and duties and freedoms enshrined in the Charter. I believe then if there are no procedures formally provided for African Commission that are not strategic, that are not consistent and systematic, then the African Commission initiatives that have been started or initiated will be in vain. The question I would like to leave with us to ponder on is on how we can all support to set up or appoint 4 officers that will be specifically for follow-up on implementation of decisions, since we are all from different places. And I believe we are all arms and legs of the African Commission. With a concerted, systematic, and consistent effort, the African Commission, therefore, is more than able to develop an implementation mechanism that can bolster its mandate. Thank you for listening to me.
Thank you very much, Lydia, for again also keeping to your 15 minutes. And your insightful paper as well. I think you mentioned there's a lot of factors that impede implementation, but you've also suggested tools and then identified the various tools that can be used to enhance implementation, including issues of political will. Hopefully, we'll get some insights from perhaps Pacharo and Eunice as well, in terms of political will. What is it all about? Political will on the part of states. You also mentioned the issue of the nature of the violation and the nature of the remedy may also be a factor that affects implementation. I mean, one is reminded of the Campbell case at the SADC tribunal, where efforts to implement it led to the demise of the SADC tribunal. And also one is also reminded, I mean, one case that was easily implemented at the African Committee of Experts on the Rights and Welfare of Children is the case of ACHPR versus Malawi. I think a very interesting decision. It was easily implementable. I think after following the friendly settlement system, which was also mentioned by Dr. Ayeni in his presentation as a possibility of enhancing implementation processes. So thank you very much, Lydia, for your paper, and I hope that everyone is going to interrogate it further. Without wasting further time, I'll now hand over to Dr. Chairman Okoloise, who has worked as a senior legal expert at the African Commission, but also an alumnus of the Center for Human Rights. Over to you, Chairman. You are talking about this mechanism. Everyone is talking about the mechanism. I think we had a meeting last week with the former president of the African Court, Justice Sophia Akufo in Ghana, and she mentioned this idea of a mechanism, that we need a mechanism. And I hope that, as a result of this conference and also previous conferences and also articles that have been written by scholars, we'll finally be able to say, look, let's set up this mechanism. Justice Sophia Akufo was actually mentioning also that it might be useful to actually have a desk within the African Union itself that will assist in terms of implementation. So it's interesting how suggestions about a mechanism for implementation, we're looking at the national level, we're looking at within the human rights body itself, but also the political body at the level of the African Union, the idea of setting up implementation mechanisms. So I'll hand over to Chairman now to sort of take us through his paper and his suggestion on why a special mechanism for monitoring implementation of the decisions of the Commission is the way to go, and what is the nature of that special mechanism, how will it look like, and so on and so forth. Thank you so much. Over to you, Chairman. You've got 15 minutes.
Good morning, everyone. Once again, thank you so much, Dr. Lloyd, Honorable Chair, for the kind introduction. And just before I speak about a topic, which I think is a single point of recommendation, and it's pretty straightforward, I'd like to acknowledge the Honorable Chair of the Commission, Dr. Remi Ngoy-Lumbu, and Honorable Dr. Lita Musimyo-Ghana, whom I've been assisting as a senior legal expert at the African Commission in a capacity as chair of the Committee for the Protection of the Rights of People Living with HIV and those at risk, vulnerable to and affected by HIV, as well as a capacity as chair of the Working Group on Indigenous Populations, Communities, and Minorities in Africa. As part of my work at the Commission, I've been drafting communications. I've also participated in a mission. And so coming to this conference, I was thinking about how can I properly engage from a practical point of view? And you've heard a lot of recommendations from those who have spoken before me, and I'd like to sit or rest on the shoulders of Dr. Victor Ayeni, as well as my friend, Lydia. And one thing that comes up from their presentation is the need to have a special mechanism. But why is this relevant? And why do I say that it's long overdue? So in dealing with my paper, I have a structure. So first of all, I introduce what decisions are meant by, because there's been some proposals that we should expand the mandate of the working group on communications. And honestly, from where I am standing, I don't think that's a great idea, because we need to, first of all, have a clear understanding of what decisions are and what decisions need to be implemented. So I'll talk about the current challenges in implementing the Commission's decisions and how the Commission goes about that, and the necessity for a special mechanism for follow-up. And of course, I try to go into some detail because the Commission has never had a special mechanism on implementation. So what should be the role of this special mechanism? And lastly, I will conclude. So when we talk about decisions of the African Commission on Human and People's Rights, we're looking at not just the decisions of the Commission in respect of communications. We have to look at it from a very expansive point of view. So we're looking at the conclusions and resolutions, inferences or propositions reached in respect of state party reports, of course, which has come up, but we need to have a clear understanding of this, of decisions on communications, decisions or the reports and the recommendations in there, as well as resolutions and other outcome instruments. So all of these comprise what is considered as decisions that need to be implemented. And so I look at various categories of these decisions by talking about observations, decisions, mission reports, and what have you. But I need to mention something that when we talk about the need for a special mechanism for follow-up, my approach really is to adopt an institutional approach. So far, I think in the Honorable Commissioner Lita Musimi Ogana's presentation this morning, she talked about the challenges with implementation, but the weaknesses in actually achieving the desired results. And one of the reasons for that is the lack of an institutionalized approach to implementation. And so I seek to address this by stating that of the nearly 900 decisions on contentious cases, or the over 130 concluding observations, the lack of implementation has gotten to a critical point. And so for us to actually have some achievements with respect to implementation, a special mechanism is necessary. So the role of the special mechanism really is to follow up. So when we talk about monitoring implementation, the role really is to follow up. And that language has come up over and over. So here I provide what is meant by follow up. It's a process by which the Commission monitors and seeks information on the steps taken by a state party after the delivery of its findings and recommendations in respect of this expansive scope of decisions. Now, why is an institutional approach really important in actually seeking to establish a special mechanism dedicated to following up or on monitoring implementation of decisions domestically? It is because already Rule 25 of the 2020 Rules of Procedure of the Commission allows the Commission to go these routes to actually organize its approach in an institutional way in order to achieve desired results. But as Victor Ayeni has said, the role of the Commission really is not to supervise, but it is to facilitate. So I think that is very important. And as such, in order to facilitate, it needs to have a well documented process or guiding principle for facilitating domestic implementation of its decisions. So what are the current challenges? In talking about the current challenges in the Commission actually monitoring domestic implementation of its decisions, I look at 3 points. One is the deficit currently of systematically monitoring domestic implementation. And why is there a systematic challenge with respect to the Commission strategy? It is because in the African Charter on Human and People's Rights, the Commission is not expressly bequeathed with a mandate to follow up. So the Commission has actually had a stand-up, hands-off approach because it perhaps feels that since Article 45 does not say that it has to follow up, then it may not be too aggressive in its approach. And so that has been a challenge. And also the equivocal nature of the provisions of the African Charter in this regard, as well as some of the clawback clauses, like which suggest that one state are able to adopt domestic legislation for implementation, like Lydia has said Burundi is doing now, then it means that the Commission must hands off once it has given a decision. But my paper suggests that this is not the case. The absence of any express provision in the African Charter mandating the Commission to actually follow up on its decision does not deprive it of the power to actually follow up on its decisions. And I will show this by also showing that the Commission, although it has the rulemaking power to make its own rules of procedure, has not taken full advantage in actually having an institutionalized process of monitoring domestic implementation. And I do this by taking us through memory lane in actually following the various generation of procedural rules adopted by the Commission. And you can see there that in 1988, when the Commission adopted its first rules of procedure, no mention of follow-up was made at all. And also when it revised the rules in 1995, no mention of follow-up was mentioned. And because there were now increasing cases of non-implementation, it considered that perhaps this might actually be a territory that it should venture into. So in the 2010 rules, the Commission began to recognize the language of follow-up, and we see this in rules 78, 90, and 112. And of course, with the revision of the rules in 2020, we also saw the small block. We also saw the inclusion of the rules in the inclusion of follow-up in rules 83, 93, 112, and 125, respectively. But just to show you some comparisons and contrasts in respect of these developments and the choice of language and how this has also affected the way commissioner rapporteurs have discharged their roles, I've drawn comparisons which you can actually take a look at. But just to show you, in the 2010 rules, where we had the first incidence of mentioning follow-up, we see that the Commission provided for follow-up on concluding observations. However, it said that such follow-up need to be done within the framework of promotion missions. So what that meant was that when the Commission does not undertake promotion missions, there might be no follow-up. So that was problematic for the Commission. But in 2020, we could see with the revision of the rules in Rule 83, Sub-Rule 2, besides providing for follow-up to be done within the framework of promotion missions, the Commission went a step further, and that's what is in bold in black. That Commission members may request or take into account contributions by interested parties. So in other words, for the first time, the Commission began to see how it can engage other actors such as civil society. So in this respect, you also see some deficits between the two rules with respect to follow up on amicable settlements, which is one branch of communications that the Commission was allowed to follow up on under the 2020 rules and as well as under the 2010 rules. However, the 2020 rules has some ambiguity in the sense that it does not expressly state whether or not it's the responsibility of the Bureau of the Commission, that is the chair and the vice chair of the Commission, or that of the Commissioner Rapporteur responsible for a communication to actually do follow-up on amicable settlement agreements. So that has also been why perhaps there's not been a strong institutional process of following up by the Commission under the 2020 rules. And of course, under decisions on the merits, you also see the lapses in Rule 125, which is the main rule there. However, there is still no express obligation on the rapporteur. Of course, there's a rapporteur for communications, but there's still no obligation on the rapporteur to monitor cases. So this continues to be left for commissioners to do during promotion activities. So the third aspect of this deficit is the lack of an institutionalized mechanism for following up, which has left the Commission's monitoring on autopilot. So here, I mentioned that of all the state reports and communications that have been considered, there's been no express and coordinated way in actually monitoring implementation since 1987. And it has been mentioned, and I think I was just going to skip this, in the website, you do not have a coordinated way of actually knowing what decisions have been implemented, what cases have been implemented, what recommendations in state party reports, that's incomplete observations of state party reports have been implemented. And this has also created, like, and I mentioned the previous conferences on implementation. But however, one challenge that the Commission has faced is that it has so many responsibilities, that responsibility for the entire continent of Africa, 54 countries, which are state parties to the African Charter. But then that responsibility is exceeded by very few human resource capacity. So I mentioned here that an enormous mandate and affected by meager resources will definitely lead to ineffectiveness. And of course, you have other challenges such as the lack of permanent headquarters, low budgetary allocations, extreme understaffing, and a backlog of pending cases. So in this regard, many scholars have actually bared their minds on the challenge faced by the Commission, particularly Chidodi Kalu, and there's no point repeating this here. But just to mention that the necessity for follow-up on for a follow-up special mechanism dedicated to monitoring implementation at the domestic level is relevant for many reasons. One is that the Commission's credibility continues to be at stake if it makes hundreds and hundreds of decisions without actually having a well-coordinated and institutionalized follow-up mechanism. And secondly is that there is a need for the Commission to actually more properly engage states in a way that preserves the institutional memory of the organization. So right now, just to summarize, when you have commissioners come and go, the current rapporteurship system does not work very well for the Commission, in the sense that commissioners come and go with the knowledge. And of course, you do not have a coordinated mechanism to actually preserve the knowledge of the institution. You do not have, like Dr. Victor Ayeni has said, a well-documented system that can be handed down from one group of staff to another at the Commission on implementation. And so there is a break in terms of actually having a coordinated system. So one benefit of this is that where you have a special mechanism at the Commission, that special mechanism would actually complement national authorities in actually implementing their decisions, in the sense that it's able to boost inter-institutional dialogue between the Commission and national authorities. The other thing is to formalize the establishment, functioning, and follow-up role of the special mechanism within the rules of procedure. And I think this is very, very important. We can use currently the existing provision of Rule 25 to establish that mechanism, but at the same time, we also need to revise the provision of Rule 125, which allows currently for follow-up by rapporteurs to actually recognize the special mechanism. And of course, to develop and implement comprehensive operational guidelines. And I think that one has been mentioned by someone else. But I just also want to mention that in terms of the role of this special mechanism, and I'm wrapping up, Honorable Chair, is that what should be the role of this special mechanism? One is to closely monitor the implementation of decisions and recommendations. Two is to diplomatically engage with state parties to facilitate compliance through consultations, diplomatic negotiations, technical support and assistance, and providing clarification on the obligations of states. And I think that when you have a working group doing that, then the desired results are trackable. And lastly, of course, when you have records based on the work of the working group, then you can actually have periodic reports by that working group during the public sessions of the Commission. And lastly is the importance of dialogue and diplomacy. So this part, of course, I had not seen Dr. Ayeni's presentation, but you can see that here I also stress the importance of dialogue and diplomacy. And why is the special mechanism very important? Someone has mentioned the need to establish an implementation unit, but you see, without the political will, you cannot get that done. And at the level of the commission, the work of the commission in terms of its relationship and engagement with states is led by commissioners from a political standpoint. So a working group would actually ensure that a commissioner takes the lead, or a group of commissioners take the lead in terms of actually constructively engaging with states with respect to implementation based on this paradigm. And so to conclude, I noted just a few things here that for a working group to actually be effective, there will be needs for training of staff at the commission on how to actually ensure that they support the work of this working group. I would like to end here, and I hope that based on this presentation that you'll be able to actually raise questions as to whether or not we need a working group or whether we need a special rapporteur. But I think the special rapporteur has not worked, and that a working group is in a better position to actually preserve institutional memory. Thank you so much.
Thank you very much, Dr. Chairman Okolese, for your paper. And I hope that people are going to also give their submissions in shaping it further, especially how this mechanism will look like. And it was also interesting to note the meeting of minds between yourself and Victor on the how this mechanism is going to be working in terms of the diplomacy and the dialogue. Thank you so much for your paper, and which has been very useful in terms of making that proposal on this special mechanism and how it will look like. I would like to now call upon, it's very interesting to see the judiciary actually utilizing technology to enhance processing of cases, but also implementation. And I think this has been done in Nigeria, and also it has been done in Namibia. And I think at the level of the sub-region, the ECOWAS Court of Justice as well. And to make this presentation, focusing on I think Nigeria, is Justice Aminu, who is going to take us through the utilization of the transformative digital tools and platforms in the promotion and facilitation of compliance with decisions of judicial bodies. Thank you so much, Honorable Justice. Over to you. I'll give you also 15 minutes to make your very interesting and innovative presentation on the use of technology. Thank you so much. Over to you.
Good morning, and thank you, the organizers of this conference, for inviting me to speak to such a distinguished gathering of experts and academicians, scholars on the topic, harnessing technology for enhanced implementation, leveraging digital tools and platforms to promote compliance with the decisions of the African Commission on Human and People's Rights. I stand on the already existing protocol established. The views I expressed in this presentation are mine alone and not those of the judiciary of Nigeria. This presentation elucidates the intricate utilization of cutting-edge technology. Sorry. As a means to bolster and optimize the implementation of decisions promulgated by the African Commission on Human and People's Rights. It delves into the transformative potential of digital tools and platforms in the promotion and facilitation of compliance with the decisions, thereby augmenting their efficacy and domestic impact. The rapid advancement of technology has engendered a paradigm shift in numerous spheres of society, including the realm of human rights. By embracing these technological strides, stakeholders can harness their immense potential to surmount prevailing challenges and engender an environment conducive to the realization of the African Commission's decisions. This presentation will undertake a comprehensive examination of the multifaceted dimensions underpinning the harnessing of technology for the purpose of heightened implementation. There are 4 key points to be expanded upon, which are as follows. 1, digitization of decision-making process. 2, amplifying awareness and outreach. 3, monitoring and evaluation. And 4, mitigating challenges and ensuring digital inclusivity. This presentation posits that through judicious innovative deployment of technology, stakeholders can unequivocally invigorate the sorry. It seems I'm speaking too fast for the interpreters to catch up. Sorry. As I was saying, this presentation posits that through judicious and innovative deployment of technology, stakeholders can unequivocally invigorate the challenges, implementation, and attendant domestic impact of the African Commission's decisions. I'm still too fast? No, don't worry, I'll do that, yes. By digitizing decision-making processes, fortifying awareness and outreach endeavors, implementing robust monitoring and evaluation mechanisms, and adroitly addressing germane to digital inclusivity, technology can aptly serve as a transformative catalyst in propelling compliance and advancing the realm of human rights in the African context. I have 10 slides, which is the second slide is background and significance of leveraging technology for enhanced implementation of the African Commission's decisions, which stem from the dynamic nature of the human rights landscape and the potential of technology to overcoming prevailing challenges. As stated earlier, the advent of cutting-edge technology has catalyzed a paradigm shift across various spheres of society, and the domain of human rights is no exception. The integration of digital tools and platforms presents an unprecedented opportunity to augment the efficacy of implementation efforts, thereby fostering an environment conducive to the realization of both the African Commission and African Court's decisions. The strategic adoption of technology offers a profound opportunity to expedite decision-making process, streamline accessibility, and amplify the efficiency of the African Commission and African Court operations. The assimilation of electronic case management systems, digital document repositories, and virtual hearing mechanisms represents a pivotal step towards leveraging technology for enhanced implementation. Through meticulous exploration and integration of these digital platforms, the African Commission can expedite the pace of decision-making and facilitate remote participation. The significance of harnessing technology lies in its capacity to amplify awareness and outreach, thereby fortifying compliance with the decisions of the African Commission and Court, and also by capitalizing on the vast potential of social media online campaigns, and interactive websites. Stakeholders can transcend geographical boundaries and disseminate information pertaining to the African Commission's decision with unprecedented reach and precision. The multifaceted utilization of digital tools serves to enhance public awareness among diverse stakeholders, including civil society organizations, engendering a greater comprehension of the decisions and fostering an upsurge in compliance and the attendant domestic impact. Therefore, stakeholders can harness the transformative power of technology to invigorate compliance and advance the realm of human rights in the African context. Furthermore, technology affords an unparalleled opportunity to establish robust monitoring and evaluation mechanisms which efficaciously track the implementation of the African Commission's decisions through the strategic deployment of data analytics, machine learning algorithms, and digital reporting platforms. Stakeholders can adeptly collate, analyze, and visualize pertinent data, enabling them to discern implementation gaps, identifying emergent trends, and construct targeted strategies that foster effective compliance. This innovative deployment of technology equips stakeholders with invaluable insights and tools to monitor progress, address challenges promptly, and recalibrate approaches to ensure the realization of the African Commission's decision. The purpose of this article is to provide a comprehensive examination of the multifaceted dimensions underlying the harnessing of technology for the purpose of enhanced implementations of decisions promulgated by the African Commission. The article aims to highlight the transformative potential of digital tools and platforms in promoting and facilitating compliance with the decisions, thereby augmenting their efficacy and domestic impact. While the objectives of the article is to explore the digitalization of decision-making process within the African Commission and highlight the integration of electronic case management systems, digital document repositories, and virtual hearing mechanisms. The objective is to demonstrate how embracing this technological advancement can accelerate the pace of decision-making, facilitate remote participation, and engender greater transparency. To also analyze the significance of technology in establishing robust monitoring and evaluation, the mechanisms for tracking the implementations of the African Commission's decision, and also to address the challenges and considerations associated with harnessing technology for enhanced implementation. This article aims to delve into issues such as data privacy, cybersecurity, technological infrastructure, and equitable access to the digital space, particularly in regions with limited internet penetration or digital literacy. The objective is to propose strategies aimed at mitigating these challenges and ensuring that universally technology-driven initiatives are accessible and beneficial to the Commission. The importance of digital platforms in expediting decision-making procedures within the African Commission on Human and People's Rights is underscored by their potential to enhance efficiency, accessibility, and transparency. The assimilation of digital tools and platforms holds immense significance in streamlining the complex processes involved in decision-making, ultimately leading to more timely and effective outcomes. Firstly, by digitizing the management of cases, this technology enables the Commission to handle an ever-increasing caseload more efficiently. Secondly, digital platforms play a crucial role in ensuring accessibility and inclusivity in decision-making procedures. The African Charter on Human and People's Rights, a key policy document guiding the work of the African Commission, emphasizes the importance of accessibility and participation of individuals and groups in the Commission's activities. Digital platforms enable remote participation, allowing stakeholders to engage in decision-making processes, regardless of their physical location. This is particularly significant in a context where the African Commission deals with issues affecting a diverse range of individuals and communities across the African continent. By leveraging digital platforms, both the Commission and courts can facilitate meaningful participation and engagement of stakeholders, including victims, civil society organizations, and other interested parties who may not have the means or ability to physically attend hearings or meetings. Thirdly, digital platforms contribute to greater transparency in decision-making. The African Commission's principles and guidelines in the right to a fair trial and legal assistance in Africa emphasize transparency as a fundamental principle underlying fair trial guarantees. By utilizing digital platforms, the African Commission can enhance transparency by providing public access to relevant information, including decisions, reports, and supporting documents. This enables interested parties to follow the decision-making process and understand the rationale behind the Commission's decisions. Online platforms such as the African Commission's official website can serve as repositories of information making decisions and related materials easily accessible to the public. The integration of electronic case management systems, digital document repositories, and virtual hearing mechanisms plays a pivotal role in expediting decision-making procedures within the African Commission. And these digital tools not only enhance efficiency, but also contribute to accessibility and transparency in the decision-making. Electronic case management systems serve as a fundamental component in streamlining decision-making within the African Commission. These systems enable the efficient handling and organization of cases, leading to a more streamlined and expedited process. In addition to electronic case management systems, the integration of digital document repositories facilitates efficient storage, retrieval, and sharing of documents related to the decision-making process. Digital repositories enable easy access to relevant legal documents, reports, and precedents, thereby empowering commissioners and staff with comprehensive information necessary for informed decision-making, which emphasize the importance of digital document repositories in legal settings, stating that they enhance accessibility and collaboration among stakeholders. Furthermore, virtual hearing mechanisms have gained significant prominence in recent years, enabling remote participation and facilitating the decision-making process. Virtual hearings utilize video conferencing technology to connect participants from different locations, overcoming geographical barriers and enhancing accessibility. The integration of virtual hearing mechanisms within the African Commissions will enable stakeholders, including victims, witnesses, and legal representatives, to participate in proceedings without the need for physical presence. This not only expedites the decision-making process, but also enhances inclusivity, particularly for individuals who may face practical challenges in attending in-person hearings. Benefits of technology in accelerating decision-making, facilitating remote participation. And by leveraging digital tools and platforms, stakeholders can harness the transformative power of technology. I've stated that earlier. Let me move on to the 7th slide. Amplifying awareness and outreach. By utilizing technology for widespread dissemination of information about the African Commission's decisions through effective use of social media, online campaigns, and interactive websites, and enhancing public awareness among diverse stakeholders, including civil society, Keeps disappearing, I'm sorry. Including civil society organizations, the utilization of technology for the widespread dissemination of information about the decisions of the African Commission is of utmost importance. Digital tools and platforms offer novel avenues to enhance the visibility, comprehension, and accessibility of the Commission's decisions amongst diverse stakeholders, including, as stated earlier, civil society organizations and the general public. In addition to social media, interactive websites serve as valuable resources for disseminating information. These websites can provide comprehensive and up-to-date information about the decisions, including summaries full of text and related documents. Monitoring and evaluation, establishing robust monitoring and evaluation mechanisms using technology is a crucial step in ensuring effective implementation of the decisions made by the African Commission. Leveraging data analysis, machine learning algorithms, and digital reporting platforms is instrumental in enhancing the implementation of decisions made by the African Commission. Also, tracking implementation progress, identifying gaps, and devising targeted strategies for compliance are essential components. Mitigating challenges and ensuring digital inclusivity. And I have potential challenges in harnessing technology for implementation enhancement that need to be acknowledged and addressed. But because of the time, I'll just list them out. There's data privacy and security concerns, which pose significant challenges in the utilization of technology. Secondly, there's cybersecurity, which is essential to protect technology, infrastructure, and data from unauthorized access, breaches, and malicious activities. So deploying robust cybersecurity measures, including firewalls, intrusion detection systems, etc., against cyber threats and maintain the integrity and confidentiality of data. 3, limited technology infrastructure in certain regions may impede the effective harnessing of technology for implementation enhancement. 4, there's resistance to change and technological adoption among stakeholders can present challenges in implementing technology-driven initiatives. 5, there's the cost implication associated with technology implementation, which can be a significant challenge, particularly for resource-constrained organizations. 6, ethical considerations and biases in technological solutions require careful attention to ensure fairness and avoid exacerbating existing inequalities. And I have strategies to overcome challenges and promote universal access to technology-driven initiatives. Then I'll go on to the conclusion. To conclude, this article has explored the conclusion is just, the article has explored the various dimensions of leveraging technology for enhanced implementation in promoting compliance with the decisions of the African Commission on Human and People's Rights. The key points discussed in the article include the integration of electronic case management systems, digital document repositories, virtual hearing mechanism to expedite decision-making procedures, facilitate remote participation, and ensure transparency. The benefits of technology in accelerating decision-making, facilitating remote participation, and ensuring transparency have been highlighted. Furthermore, the article has emphasized the effective use of social media, online campaigns, and interactive websites for widespread dissemination of information about the African Commission's decisions. By utilizing these digital platforms, public awareness among diverse stakeholders, including civil society organizations, can be enhanced, leading to increased compliance and domestic impact. The article also emphasized the importance of establishing robust monitoring and evaluation mechanisms using technology by leveraging data analytics, machine learning algorithms, and digital reporting platforms. Stakeholders can track implementation progress, identify gaps, and devise targeted strategies for compliance. Moreover, the article highlighted potential challenges in harnessing technology for implementation enhancement, including issues of data privacy, security, technological infrastructure, and equitable access. Strategies to address these challenges and promote universal access to technology-driven initiatives were discussed, including infrastructure development, digital literacy and skills training, public-private partnerships, localized content, and policy and regulatory frameworks. Looking ahead, the implications of technology-driven initiatives in promoting compliance with the African Commission's decisions are significant. Technology can serve as a transformative catalyst, invigorating the implementation and domestic impact of the decisions. By leveraging technology effectively, stakeholders can overcome challenges, enhance public awareness, ensure transparency, and track implementation progress, ultimately advancing the realm of human rights in the African context. In light of these discussions, future prospects and recommendations for leveraging technology or enhanced implementation include continued investment in technological infrastructure, expanding digital literacy, and skills training programs, fostering collaboration between public and private sectors, tailoring initiatives to the local context, and establishing supportive policy and regulatory frameworks. Overall, by harnessing technology and embracing its transformative potential, stakeholders can promote compliance with the African Commission's decision, foster greater transparency and accessibility, and ultimately advance the protection of human rights in the African continent. Thank you for listening.
Thank you very
Sorry
much.
for speaking so fast. I'm used to maybe reading my judgments very fast.
Yeah. Thank you so much for your comprehensive paper. And I hope that the Commission will take that challenge on utilizing technologies to enhance implementation of its decisions. Thank you so much, Honorable Judge. I will now hand over to the Acting Executive Secretary of the African Commission, Ms. Abiola Idojo, to respond to the 4 papers. We have 15 minutes. We're supposed to end at 12:15, but I will extend so that we have your response to some of the suggestions that have come through. Thank you so much. Over to you, Abiola.
Thank you very much, Mr. Moderator. And a very big thank you to all the panelists. I will try to respond to these powerful papers within the 15 minutes that you've given me. But first, I would like to appreciate the objective analysis that have been made by the respective panelists. And we've taken note of all the salient recommendations that have been put on the table. As I said at the beginning of this meeting, at the Commission, we consider this meeting to be a marketplace of ideas where we would take as much as possible on board for purposes of enriching our processes. My responses, therefore, are not in defense of the Commission or to answer all the questions that have been raised, but rather first to appreciate, to provide context where I need to, and practical updates also for a better engagement with the panelists and also to be able to get the best out of this conference from the panelists as well as from all the critical stakeholders that are in this room. I'm glad that most of the panelists have recognized the general nature of the problem of implementation. And particularly my brother, Dr. Chairman Okoloise, did identified the fact that the African Commission, which is mandated under the Charter, does not have an inbuilt enforcement mechanism in the Charter itself. I think at best, we have Article 54, which says it should report to every meeting of the Assembly of Heads of State and Government of the AU, as well as Article 58 that requires it to refer matters of massive violations of human rights. These are the only frameworks for basically highlighting or escalating its findings to relevant political actors, but this was not even defined in the context of implementation. So as such, the Commission and what it has done over the years has been sheer ingenuity, sheer creativity. And I say this because even if you looked at the mandate of the Commission as it is, it's very open-ended, it's extensive, and all that has been done up to date has been a lot of creativity, working together with diverse stakeholders like yourselves to bring life to what on paper seems to be almost impossible to achieve. The other point that I would like to also highlight before I go into the contextual issues is the issue of human resources, which I pointed out at the beginning. I'd mentioned that there are three, in the list, 3 dimensions to the challenges of the Commission. There is the legal question of the binding nature. There is the question of political will, which I will address shortly. And then the issue of resources, resource constraints. And my brother chairman, who also came on ground and joined us for a couple of years, has also highlighted this. I think when people come to work within the framework of the Secretariat of the Commission, they come to terms with the serious constraints within which the Commission is working. Having said that, I would like to respond first to the paper by Dr. Ayeni. You underscored the importance of the Commission focusing more on dialogue and documentation, and we thank you for this. You highlighted that dialogue has already been done, but there's a need to standardize the approach and ensure that it focuses on implementation and give as much focus as possible to the issue of implementation, which is currently just considered as an appendage to other discussions. You also did mention the issue of documentation and poor data generation within the African Commission and the need for this to be improved upon and to have a coherent and consistent approach to data generation. And I think this was also reiterated by a number of panelists. I want to acknowledge the fact that we are poor on data, but this is an area in which the Commission is currently working in, earnestly. Of course, we lacked the capacity. As I said, my first encounter with the African Commission in 2006 as a seconded expert, I found the Commission with only 3 lawyers, 3 legal officers in 2006, 2007. I rejoined the Commission in 2012 to find 6 lawyers. And up to date, the staff, the lawyers on regular AU establishment have never exceeded 10. And they've always had to double up as the program officers, they double up as the focal points for very many responsibilities that the Commission has to implement. And it's the same thing with our 11 commissioners who are part-timers and who are focal points and special rapporteurs for all of those mechanisms that you see. All those soft law instruments that Commissioner Dr. Lisa Musimi-Ogana alluded to, all those 600-something resolutions. So please do recognize the constraints and the context within which we work. Most recently, I'd like to update this August meeting that we've onboarded a database expert who was incorporated into our structure in 2006. There's a structure that was approved in 2006, which we currently use. It's a structure made up of 46 staff members, 26 professional and 20 support staff. And Mr. Zelalem Tai is here. He just came on board, and this is one of the reasons why he's here, because it's important for him to listen to stakeholders on the importance of data collection, as well as a coherent approach to ensuring accessibility to information on the decisions of the Commission and the status of implementation. And of course, in this area, it's not enough to have a database expert. We need support. A lot of research has been done. Dr. Ayeni alluded to the study by Liret Liu and Professor Franz I recall speaking to them during the course of that research, and what was also done by himself and our late beloved Professor Hens. And we need people also to be able to, support the commission in pulling all of this together so that Mr. Zelalem can effectively build a database for the commission on this, because otherwise we will still have to fall back on these 10 lawyers. In fact, 9 now, because I'm wearing a different hat. So this is one thing that I'd like to say. On dialogue, we take note of what you've said about the need to standardize, and we've taken note of indeed the need to have a progressive approach that truly measures implementation. So it's not just enough to listen to states when they report, or maybe to go on promotion missions and just ask what's the status, but to actually have a plan of action and a systemic approach to measuring implementation up until the time that we can definitively close the file on respective cases. So we take note of this important recommendation. On the issue of the prospects of political monitoring, and this takes me to the issue of political will. Of course, for many, many years, and even up until now, there's not a lot of reporting, a lot of engagement with the decisions of the commission at political level. But the landscape is changing, I must say. For someone, like I said, who looked at the question of implementation in 2003, about the time that the OAU transformed into the AU, I've seen quite a number of changes. The first is that now the African Commission was actually explicitly mandated by the Executive Council, I think about 2015, to report on implementation. So routinely we do, but of course we don't have the details. So we have to rely on the information that we get from the parties to the case, usually the complainants. So of course with data, we will be able to report in more details on this. We also have now the PRC Subcommittee on Human Rights, Democracy and Governance, which was explicitly mandated in 2018 by Executive Council Decision 1015 to monitor implementation of decisions of the Commission and other AU organs. And this subcommittee is engaging now with AU organs that have human rights mandates, human rights and governance mandates on the platform of the African governance architecture. And the African Commission is also engaging with this subcommittee. And we hope to be having a retreat at policy level, our commissioners meeting with them shortly. We also have the linkages on human rights and peace and security, which is gaining ground within the AU landscape, the AU architecture. In the past, they were treated as separate issues with the protocol, establishing the PSC, the early warning mechanism of the AU, which is now mainstreaming human rights as a critical element of measuring and tracking early warning signals. The discussion on human rights and monitoring the situation of human rights in African countries vis-a-vis peace and security is gaining ground. And this is a context within which indeed we can plug in as a commission to give more prominence to the issue of implementation. We already having conversations, but then we also need to now refocus this on implementation of decisions as much as possible. To my sister Lydia, you talked about the Commission's various intervention and tools, but the lack of a strategic and systemic approach to using this and maximizing them. And indeed, this is also, it resonates with some of the points made by Dr. Ayeni. On data, for lack of time, I already indicated what we are doing. I would also like to say that in terms of human resources and capacity, and for some of the steps that have been taken by the Commission in implementing some of the key outcomes of the Dakar and Zanzibar dialogues, the conferences the outcomes were not abandoned. We actually have a summary of the key conclusions of those conferences, as well as a plan of action. One of the things that came out of that was the revision of the rules of procedure of the Commission to now explicitly include national human rights institutions and specialized human rights organs in member states as having the obligation to report to the Commission on the steps that they've taken on implementing decisions in the countries that they are based in. Of course, that means that the Commission has the equivalent responsibility to inform them of those decisions So again, the issue of data, and dialogue comes up, but there is that obligation now, and so that's one improvement. And of course, also Rule 83.2, as was cited by Dr. Chairman, on engaging any other stakeholders with the potential to inform the Commission. Another outcome from these conferences, which has resulted in a change within the Commission, is the revised structure of the Commission that has been submitted to the African Union, which now has an implementation unit as one of those key units that we have proposed to the African Union, and we're hoping to have positive feedback on. Because the African Union itself in 2018, in January 2018, took a decision asking the Commission to review its structure and propose a structure that is better aligned with its current mandate, because we made a case as a Commission that the current structure that we have is not aligned with the expanded scope of the mandate of the Commission. So that is what we have before the African Union at the moment. You also talked about on the need for standardization. Yes, indeed, we agree with this. And I will link this up to what Dr. Chairman said about the need to breathe life into Rule 125 of the 2020 rules by having a standardized approach. And one of the opportunities that we have now is the development of what we call practice directions. Rule 140 rather of the 2020 rules now provides for the Commission to develop practice directions on diverse aspects of its work. For years, we were plugging in with guidelines, internal guidelines, SOPs, but now we have this, and this is one area where clearly we need practice directions to pull everything together and have one clear chain of an implementation mechanism or an implementation strategy for the Commission, linking together what we have and some of the good suggestions that we have on the table. In terms of, but I would like to say as well, dear colleagues, because one of the papers, I think I was able to read some on the plane, and I did see a very important point that was made in one of the papers about the role of diverse stakeholders when it comes to implementation. The role of NGOs has been mentioned, the role of the Commission has been mentioned, but also I would like to mention the role of development partners, because it's not, first I've mentioned the issue of constraints and the need to partner with the Commission, but of course we also need to ensure as development partners as well, that we are linking up development support to the real needs of both the Commission and the countries that have the obligations to implement decisions. We've been told that these decisions are like debts. They have to be paid. So when development partners go on ground and engage with countries, what are the indices that are used to develop areas of intervention? So we also need to carefully look at the issue of support to the African Commission, as well as to relevant AU organs with human rights mandates, vis-a-vis the priorities of development partners. The priorities of development partners would always fit within the broad mandate of the Commission, no matter how far-fetched. But are they speaking to the most pertinent and the most burning issues? We have to ask ourselves these questions, because it's not enough for us to speak, but we must also take up responsibility in our respective spheres. And I think this is something that we need to look at. The issue of development assistance and how it speaks to the most burning and most pertinent issues within the African Commission and other AU organs with human rights mandate, especially as it relates to the issue of implementation, which is the elephant in the room. A recommendation was made on the issue of national implementing bodies, very critical. We take note of the practice of the ECOWAS Code of Justice, and we will take this on board. The Commission over the years has been asking for focal points, and we have some countries, I'm aware of Malawi, having a mechanism or on ground dealing specifically with the issue of the African Commission on reporting and monitoring implementation. But of course, we need to replicate these best practices. And one of the things that the Commission is trying to do in this regard, and in its 2024 work plan, is that it has introduced what we call a pre-session forum of state parties. Just like we have the NGO forum and the NHRI forums, the ultimate custodians of human rights and enforcers are states. And we need to bring them into the room and into the conversation. So the idea is also to have this platform where best practices can be shared, and countries like Malawi can bring the experiences on board. Speaking to the paper by Dr. Chairman, you mentioned the importance of a systematized approach. I think that also I have addressed. And then you also talked about the fact that the rules of procedures, in our rules of procedures, the powers are not fully used. I agree with you, but even as you highlighted in your presentation, it's been progressive because you did recognize yourself that there was nothing inbuilt in the charter itself, and the commission has progressively evolved in terms of its monitoring framework. And of course, there's room for us to improve, and all of the recommendations that we've heard today can further improve the working methods of the commission in this regard. On who follows up, Rule 112 is not explicit as you mentioned, but in practice, every case, every communication has a rapporteur. And this is also replicated in Rule 125.5 that says that the rapporteur or any other commissioner designated by the commission will follow up. In practice, they are usually the commissioners responsible for those countries. So we also have an internal mechanism for monitoring, tracking, but it's just that it's not consistent as it is. As regards the mechanism for following up on decisions, right now it's within the mandate of the Working Group on Communications, based on a resolution that was adopted in 2012. That working group has the mandate to follow up on implementation, and it does report. Since 2012, that working group has been delivering to every session of the commission what we call an audit of communications. My colleague here, Dr. I've dashed you a doctorate, Dr. Pedro Rosako, is responsible for developing a matrix of pending communications and audit, which is an analysis of the status of communications, including any information related to implementation, to every session of the commission. We've done that. We've had that consistently since 2012. As far as implementation is concerned, again, because we don't have the data, we didn't have the focal point, it was difficult to have detailed information on implementation. But now we have Madam Eunice Malotha, who is a state seconded expert from Botswana, whose work is primarily focused on this, and she's been very key to facilitate towards, in facilitating our participation in this important conference. On the issue of, on the presentation by Honorable Justice Aminu, thank you so much for all the wonderful ideas on the importance of technology, the use of digital tools and platforms. Indeed, this is one of those opportunities that we have also identified, and we hope to be able to run with at the African Commission, because as you might be aware, in 2020, under the leadership of Madam Lindiwe Kumalo, the Commission was the first AU organ to organize a virtual statutory session. And since then, we've been able to have virtual meetings, virtual engagements, virtual dialogues in different forms. And if we can do this for our sessions, we've received state reports virtually. I see why not, I don't see why we cannot use this also for our hearings on implementation, which we can standardize. I think in the past, again, it was a matter of priorities, time, inadequate resources, human resources, but also the issue of financial resources, because if you invited parties for an implementation hearing, who would pay? That was a question. So with the possibility of virtual hearings, has been explicitly presented by Honorable Justice Aminu, we can take advantage of these opportunities. Another opportunity that we see at the Commission, which we are embracing also, in terms of harnessing technology to improve our working methods broadly, is the introduction of an electronic case management system. We are working on that. We started that process already, as well as a paperless, or what we call the electronic document management system broadly. My colleague Zelalem Tai is responsible for this, and this is one of the reasons why he is here as well. We also have ongoing a study on artificial intelligence, robotics, and other new technologies, and how this impacts human and people's rights. And this study is expected to interrogate both the positives and the negatives of technology, AI, and robotics. And the Center for Human Rights also is a partner, together with the support of OSF and Ford Foundation in this regard. I'd just like to quickly also just add a few and we have of technical assistants and state seconded experts. So we have more people now. Under the rules of procedure, I've mentioned the rule 140 on practice directions. I've mentioned also the opportunity presented by the PRC Subcommittee on Human Rights. And rule 138, in recognition of the fact that we have such a subcommittee, says that the Commission can make recommendations in its reports on how its decisions may be implemented. We now have that in rule 138 of the rules of procedure of the Commission. Another opportunity under our rules, and I'd like to mention that this is also one of the challenges that we've had, is the fact that the Commission now makes provision for a separate hearing on reparations, the possibility of a separate hearing on reparations. Because it was mentioned, I think, by Dr. Ayeni, that one of the prerequisites to effective implementation is clarity of the remedies that have been awarded by the Commission in the first place. And we've had these challenges for a while. And the Commission is currently working to clarify its reparations regime. We've had situations where damages were awarded and they were contested by states as to the basis and how we reached those decisions. And of course, they can all be defended individually and based on different contexts. But now the Commission has embarked on a wide project, on the general project of clarifying its reparations regime. And related to that is the fact that our rules now allow for us to be able to have a separate hearing on reparations. So after taking a decision on a case, the Commission can now call both sides to make submissions on reparations. And this allows for conversations to already take place on what are the remedies that have been implemented and how they can be implemented. So this also allows for the Commission to be able to define, a plan of action of some sort together with the parties on how the human rights violations that are found can actually be remedied. Of course, we also have the opportunity presented by the African Governance Architecture Platform. I won't go into the details. We have joint initiatives between the Commission and other AU organs, such as the committee and the courts, on improving implementation. We are indeed, it's one of those areas, one of those things that brings us together, and we're working on such joint initiatives. My colleague, Dr. Ayaliu, might be speaking to that later. I will stop here for now, dear colleagues, and I hope there will be more opportunities to engage on these issues. Thank you very much again for the papers.
Thank you so much, Abiola, for your comprehensive response and the transparency, the honesty, and everything. That I think it is very helpful, so that people also understand what is actually happening within the Commission. That is very useful. Thank you so much. I see one, so I'll just take one contribution, unfortunately, because of time, and then I'll hand over to Tamika for logistical issues around lunch and so on and so forth. So, Chair, I'll hand over to you just for your contribution, and then we break up for lunch.
Merci. Je vais faire moins de 5 minutes parce que Abiola, que je félicite d'ailleurs, a dit la majorité des choses qui auraient pu être les miennes et que je partage également. Je félicite notre jeune collègue Chairman Okoloïse. C'est finalement à travers son exposé à lui que j'ai pu bien comprendre l'article du docteur Ayeni, de Lydia, parce que finalement, le point de rencontre de tous ces articles, c'est qu'on demande à ce qu'il y ait un mécanisme sur la mise en œuvre des décisions à l'échelle de la Commission ou bien à l'échelle nationale, ainsi que la question de l'élaboration des lignes directrices bien précises sur cette question. Je voudrais réagir par rapport à ces deux questions. Sur la mise en œuvre des décisions, nonobstant l'absence des dispositions spécifiques sur cette question au niveau de la charte, je pense que la Commission peut jouer un rôle et que nous ne manquons pas de ressources pour permettre à la Commission africaine de faire ce travail-là. Elle l'a toujours bien fait, si bien que moi, je remets en cause l'idée selon laquelle il faut créer de nouveaux mécanismes. On n'en a pas tellement besoin, la création de nouveaux mécanismes. C'est un point de vue que je donne à titre individuel. Je ne dis pas que l'idée ne serait pas la bienvenue. On n'en a pas tellement besoin dans la mesure où je pense et je confirme que les rapporteurs pays peuvent faire ce rôle-là, de suivre l'exécution de la mise en œuvre des décisions auprès des États. On n'en a tellement pas besoin, compte tenu, je pense, Abiola l'a dit, de la logique actuelle au niveau de Addis Abeba, parce qu'il faut mettre tout ceci en mouvement. On rejette toute idée de mise en place d'une nouvelle structure qui peut conduire à un accroissement budgétaire au niveau d'Addis Abeba. L'idée sera tout de suite rejetée au niveau du COREP. Deux institutions, Abiola, je peux me tromper, mais corrige-moi, dans la nouvelle structure, je pense qu'on a dit une unité sur la promotion, une unité sur la protection. Je ne suis pas certain qu'on a parlé d'une unité sur la mise en œuvre des décisions. Les mécanismes qui existent actuellement peuvent bien jouer ce rôle pourvu que l'on sensibilise le commissaire à cet égard. Je crois que le commissaire nous-mêmes, nous perdons parfois de vue le fait que, étant le responsable de la mise en œuvre générale des droits de l'homme dans un pays, nous avons également la possibilité d'interagir avec les États et de leur indiquer les différentes décisions qui n'ont pas été prises en compte ou implémentées. À la différence de la situation sur le plan national où les jugements finissent par mourir, parce que comme vous le savez, en matière pénale ou en matière civile, les jugements sur le plan national ont un délai de prescription dans lequel, si vous ne demandez pas la mise en exécution, vous risquez un jour d'être débouté. Les décisions de la commission sont éternelles, ad vitam aeternam. On peut toujours solliciter leur mise en œuvre. C'est une précision que je voulais apporter. Et la deuxième précision pour terminer, la question de l'élaboration des lignes directrices précises sur la question de la mise en œuvre des décisions. Je suis vraiment curieux de savoir ce qu'on pourrait mettre encore dans ces lignes directrices. Les règlements de 2010, de 2020 sont assez clairs à ce sujet et nous avons beaucoup à faire nous-mêmes au niveau interne en prenant conscience sur cette question pour pouvoir mettre en œuvre ces décisions. C'est ici pour moi l'occasion de dire, il y a quelqu'un qui a parlé ici d'une approche institutionnelle par rapport à cette question. Je voudrais savoir, et aucun article ne le dit, ou ils l'ont dit, j'ai été distrait, je m'en excuse si c'est le cas, le sous-comité du COREP chargé des droits de l'homme, comment on peut l'utiliser ensemble de nous, la Cour, le Comité africain des experts sous le droit et le bien-être des enfants pour qu'ils nous aident à mettre en œuvre les décisions? Je ne vois pas. Au lieu de créer des structures, il y a déjà des structures assez puissantes qui peuvent exister et qui peuvent nous aider. Troisième élément, un autre élément par rapport à cette question. Le statut d'observateur que nous donnons aux ONG, le statut d'affilié qu'ont les INDH auprès des commissions, pouvons aussi les utiliser autrement. Quand je rejetais l'idée de la mise en œuvre des mécanismes, c'est pour dire que les INDH que nous avons, étant nos partenaires au niveau national, sont les premières institutions de défense des droits de l'homme auxquelles la Commission pourrait s'adresser pour pouvoir terminer. Je termine par la question de cette plateforme électronique. Je peux vous avouer, je me trompe peut-être, tout en félicitant la juge qui nous a fait l'exposé sur ce brillant article. Personnellement, peut-être au cours d'autres débats, il faudrait qu'on m'explique encore un peu plus pour que je sois convaincu de comment ces plateformes numériques peuvent contribuer à la mise en œuvre des décisions. La mise en œuvre des décisions, c'est une question de la volonté des États. Je n'ai pas trouvé vraiment de lien entre la mise en œuvre de cette plateforme numérique qui est très importante. Nous nous battons d'ailleurs avec Abiola pour que nous migrions nous-mêmes le système manuel vers le système comme celui de la Cour, avec ce système que vous les anglophones vous appelez le paperless. Mais nous ne voyons pas. À mon niveau, moi, je ne vois pas comment cette plateforme peut contribuer, aider les États à mettre en œuvre les décisions, tout en sachant très bien, je ne nie pas, que cette plateforme peut contribuer à la transparence et à l'accès aux dossiers. Mais quant à la mise en œuvre, en quoi ça peut être, parce que vous l'avez dit, et c'est mon dernier mot, je vous le promets, parce que vous avez dit que ça sera un catalyseur, donc un élément qui va booster la mise en œuvre et qui va pousser la mise en œuvre à aller de l'avant. Je n'ai pas vu tellement comment cela est allé. Je m'excuse d'avoir perturbé le programme, mais si vous nous avez appelés ici, c'est aussi pour que nous puissions interagir à tout moment pour ce genre de questions et que ça puisse aider le débat à aller de l'avant. Je vous remercie vraiment d'avoir de m'avoir accordé la parole. Merci.
Thank you very much, Chair. So I think you raised two pertinent issues, and I'll, after lunch, I'll ask Chairman and Judge Aminu to just respond to those two issues that you've raised. But also in the interest of inclusivity, I've been made aware that Irene Desiree would like to sort of make a contribution before we break for lunch. She's online. Maybe if you can allow her. Simpiwe. You may go ahead, Irene.
Okay, thank you very much. Wait, sorry, I'm echoing. Can you hear me?
Yes, go ahead, please, Irene. Thank you very much.
Okay, thank you very much. I'll first of all like to thank all the speakers for their very brilliant presentations. And thank you, Madam Acting STC, for providing responses to the papers. And of course, our Honorable Chairperson for implementing your responses. I'll focus my intervention on the way forward, some of which have been underscored by the various speakers, specifically on the establishment of a working group on the implementation of decisions. So most speakers have recommended establishing a working group on follow-up on implementation with specific suggestions and justifications outlined by Dr. Okoloise. I would like to highlight that limited financial resources at the Commission have impacted the effectiveness of its special mechanisms, that is both special rapporteurs and working groups. So based on this, the Commission has avoided establishing new special mechanisms over the years, but has subsumed related thematic issues into its existing special mechanisms. Therefore, ensuring practical implementation also presents various difficulties. So while the working group within the Commission could be a good idea, we need to ensure financial sustainability for its effectiveness. So my proposal, therefore, is if we consider having a working group, we should look at the aspect of maybe members of the working group having different mandates in terms of like implementation of communications, implementation of state reports, recommendations, and also implementation of promotion mission reports. So that could work to ensure that we have financial resources, so it's not just window dressing. And finally, I would like to mention the fact that, which was raised also by one of the presenters, that we already have a coalition for an effective African Court on Human and People's Rights, which was established to advocate for implementation of the court's decision. So I was just wondering, it will not be too ambitious for the mandate of the coalition to be expanded to include the commission and the committee, given that some of the NGOs who are part of the coalition are already supporting these programs in the implementation of their decisions, albeit in other capacities. Thank you, I submit.
Yes, thank you so much, Irene, for your contributions. I think Lydia will respond to you after lunch. I think, Victor, many people have agreed generally with your proposal. I think it has been well received. There are no contentions. So I think the people who are going to respond, it will be Lydia, Justice Aminu, and Chairman. But Madam Lita, you wanted to say something in a minute before we break for lunch. And then I think we'll conclude after lunch with responses from the presenters. Thank you very much. Just a minute or two.
Yeah, thank you very much, Chair, for the floor. First of all, let me congratulate the four speakers. The panels were quite rich in terms of content, and we have listened and we benefit a lot from the suggestions. I just wanted to compliment the chairperson's intervention. And I just wanted to bring a bit of technical approach to implementation. Ideally, when you want to monitor implementation of anything, there are three ways of doing it. Either you inbuild it in the work that you do so that it is, it happens, it's captured throughout the process, or you do what we call reviews. You can do a midterm review if it's a project, and you can do an end of term review at the end. But in terms of the way the African Union works, periodic monitoring is inbuilt in our work. That is why we have summits every year, and we report at the summits. And in summits, we not only report on content, on what we have achieved, but we also highlight challenges that we have faced. And we highlight also how we have used the other organs of the AU in overcoming those challenges. In the summits, you have 3 stakeholders usually. You have the member states, you have the regional economic communities, and you have the AU organs. So in the spirit of reforms, we have a particular summit, the July summit, which has been devoted to coordination. And it is this summit which I think is going to make our work even better when it comes to showing value for the money of the union that we use in implementing the mandate. So I just wanted to say that if you look at statistics alone, you may miss a lot because our reports are narrative. If you want to really capture the work that the Commission or any of the AU organs does, you would have to look at the reports that we submit to the summit, because that's where everything is captured. And I think this would be a qualitative analysis more than a quantitative analysis. So human rights work is also cross-cutting. And so I just wanted to say that I think we are aware of that as a commission. In fact, I always say that through my experience of working with other AU organs, I found the commission to be one of the organs of the AU that does not work in silos, to the extent that any work that one of the special mechanism does is known by 2 other commissions who also come on board with their special mandates. And this helps us to understand and know what each of us is doing. And so the reports that come out of the commission, in my view, they break the silo. For you to be able to capture, you have to literally look, and not just at the reports, but also the inter-commission, inter-mandate work that we do jointly. So I just thought it would be good to take the floor very briefly to highlight this at this stage, and I thank you.
Thank you so much, Commissioner, for those highlights and also the insights that you've given on the inbuilt mechanisms. And I think we'll be discussing these issues, over lunch, over tea breaks, as well as in the course of the next 3 days. I'll just hand over now to Tamika, just to tell us how to proceed now in terms of the lunch and everything else. Thank you so much. Just a round of applause to the speakers.
Thank you so much, Lloyd. I think that was a very engaging and very packed session as well. And so I think that it's everyone's almost favorite time of the day, which is lunch. So I'm not going to keep you much longer. Keep it very simple. You're going to be heading out this door. And once you head out, you're going to head towards your left and you will see the dining area that's there. We do understand we have gone over time quite a bit. So we are extending the time for you guys to come back to 1:30. So I think that gives you about half an hour, 25 minutes to half an hour. Okay, sorry, I've just received word that you can come back at 1:45. Okay, so Felicia has decided to be very gracious. So please make sure that you're back and seated in this venue at 1:45, and please enjoy lunch. Yes, it is safe for you to leave your belongings in here. We will close the door and make sure that no one comes in.
Everyone, sorry, just a quick announcement. We have actually been informed that it's better for everyone to take their laptops and their things with them as they go for lunch. Yeah, so apologies, please take your personal belongings with you as you go for lunch. Thank you. Yeah, you should take them with you, please. Apologies. So yes, please. I'm sorry.
Okay. Okay. Good afternoon, everybody. I hope that you all enjoyed your lunch and you're feeling much more energized after that as well. We are going to commence with our second panel session this afternoon. And the title of this panel session is called Perspectives from AU Intergovernmental Bodies. Sorry, if I could just have everyone's attention, please, if you could all just settle down.
Chairperson, Dr. Pedro, apologies. We're getting started now. Thank you.
Thank you, Felicia. As I mentioned, the title of our second panel session for this afternoon is called Perspectives from AU Intergovernmental Bodies. There has been another change to our program. Our chair for this session is Dr. Jafet Begon, and I will now invite our panelists, Dr. Ayelu, who will be discussing the perspectives from African Committee of Experts on the Rights and Welfare of the Child, Dr. Serges, who will be discussing the perspectives from the African Court on Human and People's Rights, and Mr. Clement, who will be replacing Ms. Lindiwe Kumalo, and will be discussing the perspectives from Pan-African Parliament. Our ACHPR respondent is our Honorary Dr. Lumbu. So I'll now be handing over to our chair, who will be leading us on this panel session titled Perspectives from AU Intergovernmental Bodies. Thank you.
Thank you. The difficult task of keeping all of you awake after a sumptuous and heavy lunch lies on this panel. But I'm glad that they are up to the task. It's a distinguished panel, and in keeping with Lloyd's first phase of the conference, just to also say and flex a little bit that out of the 3 panelists, 2 are alumni of the center, Ayeleu and Clement, and I also happen to be an alumnus of the center too. So this panel recognizes the fact that the question of implementation and enforcement of decisions of the African Commission on Human and People's Rights is a much broader question than just related to that institution itself, because the Commission sits in a broader ecosystem. At the very first level, it is part and parcel of the African human rights bodies, which, as you know, comprises of the African Commission, then the African Committee on the Rights and Welfare of the Child, and the African Court on Human and People's Rights. And at a second level, it sits within a broader political ecosystem that includes the AU Assembly, the Executive Council, the PRC, and the subcommittee that the chairperson was speaking about during our morning or afternoon, early afternoon session, that are also relevant actors when it comes to implementation of decisions of this particular decision, of the decisions of the human rights bodies. So Ayeleu will speak about the African Committee on the Rights and Welfare of the Child and how it addresses questions of implementation, the status of its decisions, of implementations of its decisions, the mechanisms they have put in place, the challenges that they are facing. Similar, Dr. Serges, who also works with the African Court on Human and People's Rights, will do a similar analysis of the experience of the court. And then Clement will speak to the role of the Pan-African Parliament. In many discussions so far, the Pan-African Parliament has not featured dominantly in these discussions. And I think it's really a good thing that the organizers of this conference thought it wise to include Pan-African Parliament, and Clement will discuss what then could be the potential role or the actual role of the Pan-African Parliament in catalyzing and facilitating implementation. To set us off will be Ayeleu from the Children's Committee, who will have 15 minutes. And then also the other panelists will have equally 15 minutes. We really hope that we will stop at 3:45, because at exactly 4 p.m. we need to exit the room so that it can be made a wonderful place for you to come back for dinner. So you have an interest in ending this session at the appointed time. The floor, Ayelo, is to you now.
Check. Okay. All protocols observed. Good afternoon, colleagues. Good afternoon. Yeah. Okay. Yeah. As Dr. Jaffet indicated, and of course, as you can see from the slide, I'm going to say a few words about the African Committee of Experts on the Right and Welfare of the Child and its perspective on implementation of decisions from the committee's point of view and what's happening within the committee, but also generally on implementation of decisions, which could also be relevant for the sister organ that we have within the African Union. Why is it not moving? I may need help from the technician. It's not moving. Yeah, the arrows are not working. Am I right? No. Oh, so I have to use this. Not this one. Yeah, okay, now it's okay. All right. Thank you. So so basically these are the few issues that I'm going to highlight. I'll just mention so that we all are on the same page. The African Committee of Experts and its source of decisions. Basically, it's not different from the Commission. As you know, the committee has kind of a similar mandate with the Commission, except that it's focusing on children's rights. So it's established to monitor the implementation of the African Children's Charter. It's a specialized organ of the African Union. And then the procedures that we have with regard to following up on implementation of decisions. So maybe this could also be kind of an experience sharing forum. And from academic point of view, it might also give you some ideas for you to interrogate on the adequacy of the procedures that we have within the African Committee of Experts with regard to follow up on implementation of decisions. And then I will just focus on some of the status of implementation in terms of what has been done to follow up on implementation of decisions of the very few decisions that the African Committee of Experts has made in the context of its mandate on considering communications and the factors and challenges affecting implementations the committees take, and then I'll wrap up by providing some recommendations. So these are the sources of decisions as it has been defined in the concept note, the way we define decision for the purpose of this workshop and for the purpose of our mechanisms within the UNN. It includes, recommendations out of the communication procedures, concluding observations and recommendations, resolutions, outcome documents from fact-finding missions, for instance, or follow-up missions, promotional missions. So the committee has been established to monitor the implementation of the charter, and the charter currently has been ratified by 50 member states of the African Union. So there are 5 countries which have not yet ratified the charter. So it has not achieved the universal ratification. Out of the 50 countries, 42 of them were on the state party reporting procedure, which is one of the source of decisions within the committee. 42 of them have submitted at least one report. Yeah, there are some countries which have submitted 4 times. There are some countries which have submitted 3 times and 2 times, but 42 of them out of the 50 ratifying countries have submitted at least one report. That means the committee has up until now, since its establishment and operations in 2001, 2001 establishment and operations in 2002, has considered 71 reports from member states, from state parties. Yeah. From the 71 reports, the committee has already issued 65 concluding observations and recommendations. And when you look at these concluding observations and recommendations, of course, you can get a lot of recommendations, a lot of decisions within the context of the state party reporting procedure. Communication, this is the most underutilized mandate of the committee. Since its establishment, it's not as old as a commission, but still, it was established in 2002 with a communication mandate embedded within the charter. It's not like the UNCRC, which the communication mandate of the UNCRC was established through an optional protocol. It was not within the Convention on the Rights of the Child at the United Nations level. The committee has an intrinsic, naturally, it has a mandate to consider communications, and it is embedded within the charter. So you would expect for the committee to receive a lot of communications. Up until today, as we speak today, the committee has received only 24 communications. From the 24 communications, 9 has been decided on merit. Of course, there are some which have been decided at admissibility level. 2 of them were settled amicably. And of course, Mr. Pacharo from Malawi definitely will share his experience with regard to the amicable settlement that the committee has managed to broker between the applicants and the government of Malawi. And he has played the major role, basically. I'm sure he will share the experience, and I will also talk about that communication in a while. With regard to missions, the committee undertakes fact-finding missions, investigation missions, follow-up missions, advocacy or promotional missions. Up until today, the committee has undertaken 36 missions. Some are follow-up on status of implementation of the concluding observation. Some are on fact-finding missions, like for instance, in South Sudan, Central African Republic, Tanzania, on issues of albinism, in Mozambique, in Cabo Delgado region. The committee undertakes fact-finding missions and produces report from all these missions, which also includes recommendations, which can be relevant for the discussion that we're having. And letters of urgent appeals and resolutions are all these are sources of decisions. Now, the procedures that the committee has established to monitor implementation of all these decisions, from fact-finding missions, from concluding observations and recommendations, and decisions on communications. There are revised guidelines on reporting, which also includes what needs to be done to follow up implementation of the concluding observations and recommendations of the committee. So, the committee requests state parties to produce adequate information when they submit their periodic reports. That means they will be requested to provide information on what they have done, the measure that they have taken to implement the previous concluding observations and recommendations. So when you see the periodic reports, they have to go back to the concluding observation on the initial report and reflect on the recommendations of the committee on the measure that they have taken. So this is one way of actually following up on implementation of the concluding observations and recommendations. And then the committee also undertakes what we called already follow-up missions within 2 years of issuing the concluding observations and recommendations. Like recently, the committee was in Sierra Leone to do that kind of follow-up. And then that will also then form the activity report of the committee, like the case with the commission. So it's not like that it ends with the committee. At the end of the day, and I'm going to focus on that, all these initiatives, all these activities, all these procedures, and their findings need to be reported to the Executive Council, then to the heads of states and governments during the African Union Summit. The Commission, Court, Committee, all the organs of the African Union, including the Pan-African Parliament here, they report directly to the heads of states and governments through the Executive Council. Now, of course, the PRC has a delegated power to consider these reports. So that's also one way of following up on implementation of decisions. And then the revised guidelines on communications, it provides reports within 180 days, like the case with the commission, after the decisions are made, and with a 90 days of extension. There is also an implementation hearing. The committee has established guidelines on implementation hearing in 2018, and it has undertaken implementation hearing, and I'll talk about that after this slide. And then there are follow-up missions on communications as well. So these are all the procedures that the committee has put in place to follow up on implementation of decisions. And then finally, the committee has recently established a working group. So there was a discussion on whether the commission should consider to establish a working group or leave it with like the special rapporteur, and the honorable chairperson has also raised that question. The committee resorted to establish a working group on implementation of decisions, and that working group was established 2 years ago. It's a very young working group. What this working group has done is it has just commissioned a baseline study, which has been adopted in the previous session. Is going to be released in the coming 2 weeks. The report of that working group. So the working group decided that, okay, for the working group to undertake its activities on status of implementation of the committee's decisions, we need to really understand, and we need to have a baseline study, and that baseline study has been just finalized. And so some of the issues that I'm going to talk about, particularly factors affecting implementation of decisions, are actually taken from the findings of that working group's study on implementation of decisions. So that's also another example that we have within the committee as part of the procedures on implementation of decisions. Now, on status of communications on what the committee has done to follow up on implementations. For instance, the Uganda case, which was decided on merit, no follow-up has been done up until now, and this information is available on the website. Dr. Victor, if you can increase the score that you have given to the committee, I mean, so we can negotiate. You gave the committee the score. What was the score of the committee? It was not that bad, yeah. But you can increase because we have updated our website and made this information available on our website. So the Institute of Human Rights and Development in Africa, an open society initiative against the government of Kenya on matters related to children of Nubian descent. The committee has decided this on the merit. That was actually the first decision of the committee. Through the state party reports and other briefings from NGOs, the committee has confirmed that the access to birth registration for Nubian children has improved significantly. In collaboration with ACHPR, we have also we've been participating in the follow-up activities on implementation of decisions of that particular decision. The Talibes children's case against the government of Senegal, which was also decided on the merit. There was an implementation hearing during the 29th session of the committee. No monitoring mission has been undertaken, but the Senegal has submitted its report on status of implementation, which is also included in the session report of the committee, which is available on the website. The government, the Institute of Human Rights and Development versus the government of Malawi, which was settled amicably. The committee has received 7 reports on implementation of this decision from Malawi, and he played the biggest role in making sure that actually Malawi reports regularly and periodically, almost exactly in accordance with the terms and conditions as stated in the amicable settlement. Every 6 months? Every 3 months. So every 3 months, without actually missing the week, we used to get reports from Malawi. So that actually deserves a round of applause, no? That's a best experience that we have within the committee. So as you can see, you can see like implementation hearing was held on on the case against Mauritania, for instance, on issues of modern slavery. So there are activities which have been undertaken to follow up on implementation of decisions of the committee as part of its communications mandate. Now, with regard to factors quickly in 2 minutes, no, not in 2 minutes, in 3 minutes, sorry, Chair. With regard to factors affecting implementation of decisions, one thing that the committee has identified, particularly through the working group, the study that the working group has commissioned, is it is very important to understand the complex nature of implementation of decisions at the state level. there are a number of ministries involved. There is a role that Minister of Foreign Affairs plays. There is a role that Minister of Justice plays. There is a role that the line ministry, particularly for the committee, that it plays. So when we say that governments, they need to implement, we really need to understand which ministry, which authority within the national system takes actually the main responsibility. Particularly for the commission, for the committee, for instance, we have a line ministry responsible for children's rights issues. And we deal with the Minister of Foreign Affairs. And usually the Minister of Foreign Affairs may have enough, regional desk, which could also have a role to play in coordinating implementation of activities as it relates with regional bodies like this. So understanding that nature is very much important. Second, there is no regular and authoritative assessment of the African regional human rights bodies in terms of their performance, impact, effectiveness. There is, my colleagues from the Commission, the Code, and the Pan-African Parliament knows, there is a task force now established within the African Union Commission to actually a joint task force on monitoring and evaluation of the AU policy organs' decisions. It's a very new initiative, in addition to the PRC Committee on Human Rights, Democracy, and Governance. That is a good trend, a good initiative that the African Union is trying to address the implementation crisis that we have within the Union. Third, the challenge that we have with the Assembly of Heads of States and Governments, because at the end of the day, even if we have procedures here within the Commission, even if we have procedures within the Committee Court, Pan-African Parliament, at the end of the day, the whole process culminates with member states through the policy organs. So the Commission may make a decision if the heads of states and governments through the Executive Council say that, okay, governments are encouraged to implement the decision of the committee without urging member states to implement the decision of the committee. It matters and it affects implementation of those decisions. But that's where the challenge is coming from. The committee makes a decision against Mauritania or against any of the countries that I have mentioned, and then we go to the Executive Council, and the Executive Council chooses a word, okay, Mauritania is encouraged to implement the decision of the committee. And words have their own impact, right? In some instances, if the countries are not making noise, we may end up having a decision which says that they are urged to implement the decisions of the committee. So I think that this idea of the heads of states and governments, adherence to the principle of non-interference is something that we really need to interrogate when it comes to the human rights regime and implementation of decisions that we have. Politicization of post-education and everything have a lot of issues here that you may get it from the presentation, and derogations and their effects on implementation of decisions. This is another challenge that we are having on the continent, particularly when it comes to war, conflict zones and their responsibilities on implementation of decisions, disasters, natural disasters, COVID-19. Many countries were actually blaming it on the conflict that they are having for not implementing decisions of human rights organs. Not only the suspension from, like temporary suspension from AU during coup for instance. There were challenges that we are facing. How can we actually communicate with countries with spending obligations and commitment on human rights issues and implementation of decisions while they are actually suspended from the African Union because of coup d'etats, for instance? So the human rights obligations remains the same, and that's a position of the AU Legal Council, but that has to be pronounced properly by the human rights organs, and member states need to be on the same page with the human rights organs. So the impact and the effect of suspension from the African Union for political reasons and their obligations to continue implementing decisions of the AU organs is something that we need to interrogate, and that remains to be a challenge. Lack of reparation guidelines, lack of evidence-based public record on the status of implementation. Some decisions are not clear and measurable, making implementation difficult. These are issues that we have identified. So as part of recommendations, we need to draw inspirations from other systems, particularly the European system and the Inter-American system. As you can see, there are increasingly positive trends within these two systems with regard to implementation of decisions. So I think for the commission, the court, and the committee, we need to really draw inspiration from these systems on how they have enhanced their status of implementation of their decisions. Reference to each other's jurisprudence and others can also be something that we can consider. Just from this, I would like to highlight two of them. The first one is, from the committee's point of view, we're trying to make a standing agenda item during our session where the commission comes and actually present the status of human rights in Africa regularly. As part of that, we can also, there were instances where the committee actually makes reference to the decisions of the commission, and encourages governments to implement not only its own decisions, but the decisions of the commission as well. So information exchange is key. That platform would actually help these two organs to exchange information and support each other. The second one is, we can actually consider to develop a joint guidelines on reparations, because this is also the challenge that the committee is facing, and this is also the challenge that the commission is facing. So instead of having a separate guidelines on reparations, I think this is something that we can consider to develop it jointly. And finally, joint guidelines on the issuance and implementation of interim measures. This is also another gap that we have within the committee, and I'm sure this is also another gap that the commission is facing. So we can also consider having a joint guidelines on issuance and implementation of interim measures. And I raise my case here. Thank you very much.
Thank you, Ayello, for that really insightful presentations. It's good to see how, for instance, there have been reports on compliance filed by states, and it will be good to have a discussion of why is it that it seems that states are more likely to report back to the committee compared, for instance, to the commission or the court. So it will be good to have that discussion. You spent 20 minutes, so you are in non-compliance with the yes. Now we head to the African court. To Dr. Sajes, hope you comply with your 15 minutes.
Bon après-midi à tous. Je suis appelé à présenter cette communication sur les perspectives de la Cour africaine des droits de l'homme et des peuples sur la mise en œuvre et l'impact des décisions judiciaires des organes africains de protection des droits de l'homme. C'est la thématique qui nous a été envoyée et le greffe m'a fait ainsi l'honneur de représenter la Cour à l'occasion de cette conférence. Il convient de dire que c'est une conférence qui se situe également dans la poursuite des activités de la Cour africaine. Vous savez, en 2021, à Dar es Salaam, la Cour a organisé une conférence internationale sur la mise en œuvre et l'impact de ces décisions. Et alors, à l'heure de mon intervention, il convient de dire que la Cour africaine fait également face au défi de la mise en œuvre de ces décisions. Au-delà de ce premier défi, il y a d'abord le défi de la ratification du protocole portant création de la Cour africaine des droits de l'homme et des peuples. Parce qu'à ce jour, 34 États tout simplement en Afrique, sur les 55, ont ratifié le protocole portant création de la Cour africaine des droits de l'homme et des peuples. Au-delà du défi de ratification de ce protocole, il y a également le défi de la déclaration de compétences de la Cour africaine des droits de l'homme et des peuples. À ce jour, 8 États seulement ont déposé la déclaration de compétences qui donne la possibilité aux individus et aux ONG de saisir directement la Cour africaine des droits de l'homme et des peuples. Et on a d'ailleurs aussi fait face à 4 retraits dans les années récentes. Alors, de manière précise, la question de la mise en œuvre des décisions judiciaires, d'abord, l'expérience de la Cour africaine des droits de l'homme est assez évolutive. Donc, la Cour africaine a adopté une nouvelle politique évolutive, dans la question de la mise en œuvre de ces décisions. Cette politique peut être divisée en deux phases. Il y a d'abord une phase avant mon arrivée à la Cour africaine des droits de l'homme, parce qu'actuellement, je suis le juriste principal en charge de l'exécution et du suivi des décisions judiciaires de la Cour africaine des droits de l'homme et des peuples. Par le passé, la mise en œuvre des décisions de la Cour africaine des droits de l'homme et des peuples était confiée à un juriste, à une unité, à un juriste qui se chargeait d'écrire aux États afin de collecter les différentes informations, de compiler les différents rapports. Mais depuis lors, après la conférence de Dar es Salaam, les politiques ont évolué. Les politiques ont évolué dans la mesure où la Cour africaine des droits de l'homme et des peuples a adopté une nouvelle politique, à savoir comment procède la Cour africaine des droits de l'homme et des peuples pour le moment. Nous avons, au sein de la division juridique, mis en place une unité en charge du suivi et de l'exécution des décisions. Dans cette unité, nous avons mis en exergue les priorités, nous avons adopté des priorités, notamment en vue de l'amélioration de la coopération avec les États. Parce que l'amélioration de la coopération avec les États constitue d'ailleurs un des objectifs principaux du plan d'action stratégique 2021-2025 de la Cour africaine des droits de l'homme. Comment améliorons-nous cette relation avec les États? Déjà au sein de l'unité de suivi, compte tenu du fait que la décision 1197 du Conseil exécutif de l'Union africaine recommande aux différents États de désigner des points focaux nationaux pour améliorer leurs relations avec la Cour et particulièrement la mise en œuvre des décisions de la Cour, nous avons entrepris d'inciter les États à travers les correspondances aux fins de désignation des points focaux, notamment, nous avons ciblé les 34 États qui ont ratifié le protocole. L'objectif est d'avoir, au sein de ces 34 États, des points focaux nationaux en charge du suivi et de l'amélioration de la mise en œuvre des décisions de la Cour. Nous pouvons dire que avant la fin de cette session, puisque nous sommes en session actuellement, nous pourrons avoir les premiers résultats. Nous avons également entrepris de mettre un accent sur le dialogue, parce que le dialogue est un élément fondamental. C'est un élément qui permet à la Cour de se rapprocher des différents États qui sont en fait les débiteurs de cette obligation de mise en œuvre. Nous avons entrepris de mettre l'accent sur le dialogue. Et d'ailleurs, lors des missions de sensibilisation de la Cour aborde cet aspect. La Cour se rapproche de plus en plus auprès des acteurs étatiques compétents en vue d'améliorer ses relations avec elles. Il convient également de dire qu'en vue de la mise en œuvre des articles 80 et 81 de notre règlement intérieur qui portent spécifiquement sur le suivi et l'exécution des décisions de la Cour est en train de mettre en place un guide d'organisation des audiences de conformité. Parce que les audiences de conformité sont désormais consacrées dans le règlement intérieur de la Cour. C'est une nouveauté. D'ailleurs, à ce jour, nous avons une quinzaine de demandes d'audience de conformité. Et alors, nous avons pris en notre sein un certain nombre de mesures, notamment l'élaboration d'un guide de procédure d'audience de conformité. Nous avons également pris des dispositions pour l'élaboration d'un plan d'action parce que ça fait partie des différents outils qui entreront en compte pour la tenue des audiences de conformité, le plan d'action, le guide de procédure, le guide de procédure de tenue d'audience de conformité. Mais aussi, nous avons également, dans la même veine, entrepris d'élaborer une base de données. Ce processus est également en cours, la base de données en vue d'améliorer le suivi de la mise en œuvre des décisions rendues par la Cour africaine des droits de l'homme et des peuples. La Cour africaine des droits de l'homme et des peuples, en cette matière, a également une vision plus globale. Cette vision plus globale repose sur la collaboration, la coopération, la complémentarité avec les autres organes du système de l'Union africaine. Déjà, la Commission africaine des droits de l'homme a une feuille de route 2023-2025 avec la Cour africaine également associée à un plan de travail. Ces différents outils nous permettront de renforcer la mise en œuvre des décisions de la Cour qui est très faible. Parce que en 2020, et les statistiques n'ont pas encore changé, n'ont pas suffisamment changé. Les statistiques, le score est monté à 7% de mise en exécution, de mise en œuvre des décisions de la Cour africaine, avec 75% d'inexécution et quelque part 10% de mise en œuvre des ordonnances sur mesures provisoires. Mais il convient de dire qu'on a eu quelques évolutions qu'on peut juger quand même très minimes. Je peux citer dans l'affaire Commission africaine contre Kenya, l'arrêt sur le fond le 25 janvier 2022, la Cour africaine a reçu un rapport de mise en œuvre de son arrêt, l'arrêt rendu sur le fond, mais l'arrêt rendu sur les réparations. On n'a pas reçu un rapport de mise en œuvre puisque le délai, nous avions donné, la Cour avait donné un délai supplémentaire de 60 jours à l'État défendeur pour produire son rapport de mise en œuvre. À ce jour, nous attendons certainement à la fin de cette session. On saura si l'État défendeur a entrepris, a initié des nouvelles mesures. Il y a également, comme je vous l'ai dit au départ, dans une affaire concernant la Tunisie, nous avons eu également un dépôt de rapport de mise en œuvre par l'État de Tunisie et le requérant a également fait une observation, parce que le règlement intérieur de la Cour africaine dispose que lorsqu'un État soumet un rapport, alors le rapport est transmis au requérant pour observation. Le requérant a la possibilité de contester le rapport, alors en ce moment naît un différend. Et la Cour, face à un différend, pourra apprécier ou pas le statut, pourra apprécier le statut de la mise en œuvre et envisager également la tenue d'une audience de conformité. Et si la Cour n'envisage pas la tenue d'une audience de conformité, la Cour inscrira dans son rapport de fin d'année, dans son rapport annuel, le statut de la mise en œuvre de cette décision qui sera transmis au Conseil exécutif. Cela me permet de dire qu'au sein de la Cour, nous avons également élaboré des critères qui permettent de déterminer la tenue ou pas des audiences de conformité. Ces critères feront l'objet d'un examen par la Cour afin de pouvoir savoir est-ce que toutes les demandes peuvent faire l'objet de tenue d'audience de conformité. La Cour pourra apprécier. Parce que l'article 81 nous dit 81.3 dit pour qu'il y ait audience de conformité, il faut qu'il y ait un différend. Alors nous pourrions en ce moment apprécier la nature du différend. Je disais tantôt que nous avons, au-delà de la collaboration, de la complémentarité envisagée, la complémentarité que nous voulions de plus en plus efficace et effective avec la Commission, nous avons également des initiatives de complémentarité, de collaboration avec le Comité africain des droits et le Comité africain des espèces sur les droits des enfants. La collaboration avec la Cour de communauté de l'Afrique de l'Ouest, la Cour de justice de la communauté de l'Afrique de l'Ouest, ECOWAS. Nous avons un mémorandum d'entente et un plan de travail également qui porte également sur la promotion de la mise en œuvre des décisions de la Cour. Il y a également une collaboration inscrite dans un mémorandum avec la Cour de la communauté de l'Afrique de l'Est. C'est pour dire que nous avions une vision, la Cour africaine a une vision holistique plus globale de la complémentarité en vue de l'amélioration de la mise en œuvre de ces décisions. Elle s'inspire également d'autres expériences enrichissantes, telles que l'expérience de la Cour interaméricaine des droits de l'homme, la Cour européenne des droits de l'homme, parce que il y a un forum des trois cours, un forum biennal des trois cours qui s'organise après tous les 2 ans en vue de partager les expériences et de mutualiser les bonnes pratiques en vue de l'amélioration en vue du suivi efficace et la mise en œuvre des décisions des différents organes. La Cour envisage donc, dans le déroulement de sa feuille de route, avec la commission ici présente, avec le comité et certainement avec la participation de votre centre, de renforcer l'amélioration de ces décisions, de la mise en œuvre, non pas seulement de ces décisions, mais aussi des décisions des autres organes, parce que le fait déjà pour nous de citer les communications de la Commission africaine des droits de l'homme, du comité, ainsi que les références aux arrêts des autres organes, c'est un moyen de montrer, de mettre en exergue l'impact des décisions rendues par ces organes. Et cela montre également que ces décisions, visibles par la référence à elles, pourront inciter les États et toutes les parties prenantes à mettre en œuvre ces différentes décisions. Je pense que si j'ai pu respecter le temps qui m'est imparti, et je vous remercie.
Thank you, Dr. Sajis. You actually used exactly 15 minutes from the time you started. So thank you so much. There is a running theme, I think, from morning to now. We see the role of monitoring units, government focal points, emphasis on dialogue, guidelines on compliance or implementation. So I think that's really a running theme that is coming through. And I think Professor Remy, when you respond to this particular discussion, perhaps it will be good to hear from you the place of implementation hearings at the African Commission, which is already envisaged under the 2020 rules of procedure, if since then there has been any implementation hearings, and what experience has been at the African Commission. At this point, and I've also just remembered that while I'm busy ensuring that my panelists keep time, tomorrow the roles will change and Ayelo will be the moderator when I make my presentation. So I wanted to use this opportunity to ask, make an early application that you be gracious tomorrow. We shift gears now to the Pan-African Parliament. Clément, the floor is yours for the next 15 minutes.
Thank you, Mr. Moderator, for giving me the floor. Since I have time that is counted, I'll be very fast. It has been said that perhaps it's only now that the Pan-African Parliament is coming into the picture of reflections on implementation of human rights decisions. And it is indeed perhaps something that has been missing. My task here is to propose to you that the Pan-African Parliament can be an antidote to the crisis of implementation of decisions from African human rights bodies. And B. So, and since PAP is not very well known, I'll just quickly introduce the Pan-African Parliament in its mandate. I'll not go into structures and workings in the interest of time. And there's a question that has been being posed as to whether PAP has some mandate in relation to human rights. And I say yes. And it is from that mandate that I will land to discuss its role or its potential role as far as human rights, implementation of human rights decisions are concerned. The Pan-African Parliament was established as a legislative body of the African Union, basically expected to work in collaboration with the constellation of all African Union organs, institutions, and agencies. Established under the Abuja Treaty in 1991, up to 1999, PAP could not be effectively in operation. It took the African Union Constitutive Act to reiterate the need for a Pan-African Parliament. And it was the 6th protocol in 2001, which actually established the Pan-African Parliament, outlining its powers and modus operandi. 2 years later, it entered into force, and 1 year later, the PAP was inaugurated in Addis Ababa. In 2014, a new protocol, which we call the Malabo Protocol, was adopted. Up to now, this protocol is not yet into force, although it has basically garnered some 23 signatures and 50% of the required ratifications. A protocol which is basically acclaimed to vest the Pan-African Parliament with full legislative powers. But let's go to the mandate. The Pan-African Parliament, as any parliament, has a mandate which includes the four traditional functions: budgetary function, oversight, quasi-legislative, and other functions. And I wanted to put it this way so that already you can see a transparency of the role of the Pan-African Parliament when it comes to human rights decisions, particularly the remedies that are proposed by the human rights bodies, some of which fall down to budgetary implications, the need for oversight, the need for a specific law to be enacted, but even the need for other follow-up mechanisms. And this mandate stems from Article 11 of the Pan-African Parliament Protocol, which says the Pan-African Parliament shall examine, discuss, or express an opinion on any matter, any, and I like highlighting any, either on its own initiative or at the request of the African Union policy organs. So this has not yet happened in the history of PAP, almost 20 years, but at least on its own initiative, the Pan-African Parliament can examine, discuss, or express an opinion, take action in respect to human rights, democracy, and other shared value instruments. Secondly, it is important to highlight that Article 18 of the PAP Protocol creates a bridge between the Pan-African Parliament and the national and parliaments of the member states, and also parliament of the regional economic communities. And this is basically to start drawing up probably a mechanism through which the Pan-African Parliament can mobilize or trigger action vis-a-vis the member states, which can lead to implementation of human rights decisions. Secondly, and maybe lastly, Article 3 of the PAP Protocol again reinforces the relevance of PAP vis-a-vis the AU shared values, particularly human rights. I'll move to basically say that the Pan-African Parliament has tried to use these provisions in its activities to ensure that it responds to human rights issues, particularly undertaking fact-finding missions, discussing human rights issues in Parliament, but also exercising some sort of soft oversight over other organs of the African Union, but also over the member states. And the Pan-African Parliament has particularly used its unique position vis-a-vis the member states to discuss specific issues, and some of which relate to human rights issues. Also, the Pan-African Parliament, in its rules of procedure, Article 72, has laid down a process through which African citizens can submit complaints on any matter affecting them, including human rights issues. But the question could be, is a beneficiary of a human rights decision from the African Court or the African Commission approach the Pan-African Parliament for lack of implementation? It's a good question to ask, but I think it is something that is possible. And what is also interesting is that the procedure or the Pan-African Parliament petition process or procedure is less formalistic. It is less formalistic, which means that the petitioners are more likely to get an outcome faster than they would elsewhere. Let me just skip before the chairperson could show me the flag. So I also coming to the issue of decisions that have, in order for a specific law or national law to be repealed, amended, or adopted, the Pan-African Parliament also has a role in terms of assisting the member states through formulation of model laws. And right now, we have on our left-hand side some model laws that have been developed so far and adopted. And on the right-hand side, those that are still in the pipelines. The role of the Pan-African parliaments in relation to human rights generally, I think it's not or no longer a subject for debate, because you can see the objectives and mandates and functions of the Pan-African Parliament clearly defined in the African Union Treaty law, but also the institutional position between Pan-African Parliament and the national parliaments, which can be triggered, and the special role and functions of PAP members, noting that every national parliament is represented by 5 members of the Pan-African Parliament, and nowadays there's an obligation for all the 5 members to take action at the level of their respective national parliaments to ensure that the resolutions adopted at the PAP finds their way in the discussions and the outputs of their national parliaments, and which means that they can also be channels through which human rights decisions endorsed and discussed at PAP can find the way at the national parliament, whether under the exercise of the oversight, budgetary, lawmaking power at the national level. Also, as I said, the Pan-African Parliament has an ability to adopt model legislations, particularly where the Commission or the courts so directs, and it can probably be a way of triggering or initiating or even supporting the member states to have legislations that are human rights compliant. We try to basically ask ourselves, perhaps somewhere else this is being done. Now, there seems to be a habit of referring to the European Parliament, but actually the Parliament that is more closer to the mandate and functionalities of the Pan-African Parliament is the Parliamentary Assembly of the Council of Europe. And when you look into its mandate and the procedures, although it has a different context and institutional dynamics, coming from the fact that actually in the Council of Europe, it is the basically the European human rights system is an emanation of the Parliamentary Assembly of the Council of Europe, because the adoption of the European Convention on Human Rights was actually a recommendation of the Parliament, and so the Parliament existed before the treaty. While at the Pan-African Parliament was even set up about 20 years after the adoption of the Charter, and probably That's why looking at the various human rights treaties, African human rights treaties, the role of the Pan-African Parliament might not directly feature, although it then arises within its own protocol. Secondly, when you look properly, you will see a similarity in the mandates and functions. The PACHE has a role that stems from standard setting to even the election of judges of the European Court and all the way to implementation. They have adopted several resolutions calling for specific member states to take action and using their own judges to take action at the national level for implementation of human rights decisions. And also where there's need for budgetary allocation, the PACHE has been also on the forefront of pushing for the member states to allocate the necessary budgetary means for specific decisions to be implemented. And we believe that the Pan-African Parliament can actually learn, but basically use its mandate as defined in its protocol, learning from the journey of the Parliamentary Assembly of the Council of Europe. We believe that doing so will not have legal or institutional implications because it will not require any new instruments, legal instrument to be adopted. It will not require any new institution to be in place because the Pan-African Parliament can use its Permanent Committee on Human Rights and Justice as an engine for advancing implementation of human rights decisions. There will be no budgetary implications per se, because the committee and the Pan-African Parliament as an institution can just use their current role and resources to be able to deal with the issue of non-implementation of decisions. And then it will be coherent with the core African Union principles and policies, because right now an emphasis is being made on collaboration between the various organs. And we believe that under the AGA framework, the role of the Pan-African Parliament will be seen as a complementarity role to the various human rights bodies. But also it will exemplify also this relationship and collaboration between continental institutions and national institutions. And lastly, since the Pan-African Parliament was created as a platform for citizens of the continent, it will basically exemplify again and centralize the place of African citizens within the framework of implementation of decisions of African human rights bodies. Thank you, Mr. Chair.
Thank you, Clément, for highlighting the mandate of PAP in relation to human rights, but even more importantly, the potential role that it could play. And I think one of the profound points you've made is the role of Pan-African Parliament as a bridge between the African Union and national parliaments and parliaments of regional economic communities, and the role that you could do to mobilize parliaments and the national and the relevant committees within those parliaments to actually play an oversight role at the domestic level in terms of implementation of decisions of regional bodies. Thank you so much, all the three panelists, for very insightful, very thought-provoking points. I now want to invite Honorable Chairperson, Professor Remy, to make a few remarks in response to the three presentations. Honorable Chairperson, 10 minutes in response.
Merci beaucoup. Je promets que je ne ferai pas plus de 10 minutes. La première chose d'abord, c'est d'apprécier la qualité de tous nos trois collègues qui se sont succédés dans ce panel. Le collègue Getachou, le collègue Serge, le juriste principal chargé de la mise en œuvre au niveau de la Cour, ainsi que notre collègue Clément Mavungu, qui est également juriste au Parlement panafricain. La lecture horizontale de tous ces trois organes donne effectivement plusieurs leçons que nous connaissons déjà, mais qui rafraîchissent également notre mémoire. Et ces trois leçons trouvent un motif légitime, pour en soi un motif légitime de collaboration qui peut exister entre nous et ces trois organes, avec le comité africain sous mon leadership, le comité africain des experts sur le droit et le bien-être de l'enfant. Ce bureau dont j'assume la présidence a déjà initié un MOU, et dans le cadre de ces Memorandum of Understanding, il y a des ponts de collaboration qui peuvent être créés pour la mise en œuvre de nos décisions respectives. Il y en est de même de la Cour. Je crois que le juriste principal a rappelé ici la feuille de route que nous avons signée avec la Cour à partir de Addis Abeba. J'assurais moi-même le leadership de l'équipe qui était partie négocier ça avec la Cour. Nous avons également des possibilités de réaliser des ponts de collaboration en matière de l'implémentation des décisions. Pour le Parlement panafricain, nous venions récemment de signer aussi un Memorandum of Understanding avec Son Excellence le Président Charumbira. Dans ce cadre-là, nous avons des ressources pour pouvoir collaborer. À ce stade, ce que la Commission africaine pourrait dire, c'est que cette maladie, ce cancer qui ronge les trois organes sur la mise en œuvre des décisions, n'a pas de solution toute faite et bien tracée. Depuis ce matin, vous avez remarqué, c'est une espèce de boîte d'outils, boîte à outils, dans laquelle à chaque instant, il faut aller puiser l'outil nécessaire comme un plombier pour savoir si c'est avec la clé numéro 11 qu'il faut fermer tel robinet ou s'il faut utiliser le pince pour pouvoir arrêter une fuite d'eau, etc., etc. Et ces boîtes d'outils sont riches en éléments. Certains, nous les appliquons déjà. Par exemple, lorsque le comité africain des experts parle de missions de suivi, nous le faisons. Lorsque nous faisons nos missions de promotion, on ne peut pas dire qu'il s'agit effectivement de missions de suivi, mais c'est des termes qui changent. Dans ce cadre-là, nous faisons également les missions de suivi. Abiola me rappellera, mais nous n'avons pas de ligne directrice à proprement parler sur la mise en œuvre de nos décisions elles-mêmes. Mais c'est une piste que nous pouvons explorer, comme le comité africain l'a fait, voir également nos propres lignes directrices. Mais comme je l'ai déjà dit, ce ne sont pas les textes qui font défaut, hein. Nos règlements intérieurs fourmillent de beaucoup d'informations qui peuvent nous aider dans la mise en œuvre des décisions. Peut-être l'élément nouveau sur lequel nous pouvons songer, nous trouvons déjà une forme de réponse, c'est cette fameuse groupe de travail sur la mise en œuvre des décisions. Et c'est ça, la jonction avec la session numéro 1, lorsque la session numéro 1, animée par Lydia, par Chairman, par Ayeni, et que je remercie encore de nouveau, même par Madame la Justice Fatima, qui ont parlé des mécanismes de mise en œuvre des décisions. Si ça peut paraître sous forme de groupe de travail sur la mise en œuvre, la commission n'est pas fermée par rapport à cela. Bien que j'ai dit ici que les questions budgétaires nous empêchent de créer régulièrement des groupes de travail, mais il est possible que par des mécanismes internes, qu'on en élimine certains, on fusionne d'autres compétences et arriver quand même à avoir une structure nette qui s'occupe du groupe de travail sur les décisions, dont les premières réponses ont déjà été données, comme m'a signalé la secrétaire exécutive Abiola, à travers la nouvelle structure que nous avons. Il y a toute une unité juridique à travers laquelle, comme à la Cour, on pourrait trouver une unité chargée de la mise en œuvre de décisions. Nous pouvons prendre également exemple de la Cour qui avait par le passé, comme il l'a dit, un juriste qui faisait le pont, le dialogue seul avec les États, système déjà abandonné. Peut-être nous pouvons aussi regarder à cela parce que nous avons des rapporteurs pays. Si ça n'a pas produit de fruits au niveau de la Cour, peut-être chez nous, ça pourrait également être la même chose. Il faut toujours s'inspirer des bons exemples des autres et migrer alors du système des rapporteurs pays et que nous avons jusque-là, qui n'est pas assez utilisé en matière de mise en œuvre, migrer vers la mise en place, comme eux, ils ont une division au sein de laquelle il y a une unité en charge de l'implémentation. Si notre structure est adoptée demain, parce que c'est une nouvelle structure, je crois que nous pouvons défendre les choses de cette manière-là. J'apprécie beaucoup ce qu'a dit le juriste Mavungu, la crise de l'implémentation des décisions, le Parlement pourrait être une panacée par rapport à la question. Donc, la solution par rapport à cela, on attend voir cela. Si, dans le cadre de MOU que nous avons signé, nous pouvons faire part au Parlement de nous assister dans la mise en œuvre de nos décisions parce qu'ils ont cette possibilité, ayant des parlementaires nationaux qui viennent siéger à migrants et qui retournent dans leur pays. Et on sait qu'au sein du système national, il y a des unités en charge des droits de l'homme. On pourrait toujours activer et voir comment le fruit pourrait être recueilli par rapport à cette complémentarité entre nous et le Parlement panafricain, s'ils peuvent nous aider à travers les parlementaires. Cela, ça ne peut pas dire que c'est l'unique méthode. Nous pouvons l'utiliser par rapport à certains cas, peut-être par rapport à d'autres, c'est toujours recourir au mécanisme classique que nous avons. Mais ce qui me réjouit avec tout ce que nous avons fait, c'est le fait que on se rend finalement compte que s'il n'y a peut-être pas de mise en œuvre de nos décisions au niveau de la Commission, ce n'est pas parce que les pistes manquent, ce n'est pas parce que les ressources manquent. Il y a des ressources internes propres à la Commission africaine, tout comme il peut utiliser les ressources venant des autres organes, les moyens qui sont proposés par les autres organes pour pouvoir y arriver. Il apparaît bien clairement que le groupe de travail sur la mise en œuvre, c'est une idée qui, depuis le matin, est en train de faire son chemin et qui, dans ce cadre également, est rappelée. Je voudrais terminer, pour ne pas abuser de votre temps, indiquer quand même que malgré tout ce tableau que nous présentons, on ne peut pas se cacher que de dire que ce ne serait pas une erreur ou bien je ne serais pas porter une mauvaise accusation sur tous les organes, en ce compris le nôtre, c'est que la mise en œuvre des décisions reste une question problématique. Nous continuons à insister. Et c'est peut-être demain, je ne sais pas s'il y aura des représentants des États ici, sous le fait que la volonté des États reste l'élément premier sur lequel nous devons travailler. Il suffisait que les États soient simplement collaboratifs par rapport à cette question pour qu'on n'en arrive pas à trouver les voies et moyens pour pouvoir appliquer. Et le dernier mot, je sais qu'au niveau de la Cour européenne des droits de l'homme, le comité des ministres a été institutionnalisé pour assurer le suivi des décisions de la Cour européenne des droits de l'homme. Mais ici, vous avez vu deux institutions, aussi bien le Comité africain des experts sur le droit et le bien-être des enfants, dans leurs recommandations, nous inspirer du système européen. Clément Mavungu également, même la Cour africaine, ils disent que ils aimeraient aussi prendre les exemples parce qu'ils ont cette triennale, Cour africaine, interaméricaine et Cour européenne des droits de l'homme. Ils veulent aussi s'inspirer de la manière dont les Européens le font. Vous voyez que Clément Mavungu également a ajouté le fait que l'Assemblée parlementaire de l'Europe, au sein du Conseil de l'Europe, qui est l'équivalent de l'Union africaine, cette Assemblée parlementaire joue également un rôle au niveau de l'Europe et qu'ils aimeraient également jouer le même rôle dans la mise en œuvre des décisions. C'est peut-être l'élément qui nous manque, nous autres. Nous n'avons pas l'expérience européenne parce que nous n'avons pas un organe équivalent au niveau de l'Europe aujourd'hui, l'ancienne commission ayant déjà été supprimée au profit de la Cour. nous pouvons apprendre de ces autres organes les expériences que eux, ils peuvent tirer du système européen dans ce cadre-là. En conclusion, en 2 mots, ces échanges sont riches. Il y a des ressources qui existent et les organes ne peuvent pas vivre. Un organe comme la Commission, qui est la plus ancienne de toutes les 3, ne peut pas vivre en autarcie, là où elle sent qu'elle a des limites pour pouvoir mettre en œuvre ses décisions. Elle peut soulever d'autres leviers, les autres organes qui sont nés après lui, parce qu'ils disposent également de ressources capables de l'aider à mettre en œuvre ses décisions. Voilà, c'est 10 minutes maintenant. Je ne voudrais pas vous prendre une seconde de plus. C'est ça les leçons que je tire de tout ça.
Thank you. Thank you. Yes, I kept time and I love a few of the points that you have made, beginning, of course, from the fact that we have a toolbox from which we can be able to choose the different means and methods of ensuring enforcement and compliance. Thank you so much, Honorable Chairperson. We have exactly 35 minutes of discussion. But how we use that 35 minutes will depend on how conscious and precious the speakers will be. So to allow as many of us to be able to contribute to the discussion, I'll open up the floor for a plenary discussion, but let's be very direct and conscious on the points that you want to make or the question that you want to make. If it is a question, please point it directly to one of the panelists. If it's a question that emanates from morning discussions, make that also clear. I'll open up the floor. Okay. I think I'll also be alerted if we have online participants who would like to join the conversation. Please raise your hands and then we'll give you an opportunity. Let's start from here. I'll take a round of comments or questions and then we'll see whether we have Chairman. As you can see, I'm ignoring you for now. Yes.
Merci beaucoup. Je voulais poser une question que je pense que elle peut être répondue par Dr. Ailo et aussi par Serge. J'ai suivi leur présentation, la question du suivi, surtout la question de l'audience pour discuter le suivi et l'implémentation des décisions de leur juridiction. À un certain moment, j'ai compris que le rapport qui est soumis au conseil exécutif, c'est plutôt un rapport sur la non-exécution. Ce n'est pas un rapport sur l'exécution. Donc, c'est la non-exécution qui est soumise au conseil exécutif. Ça veut dire que il faut que les 2 organes décident et constatent par voie judiciaire sur la non-exécution. On ne peut pas reporter au conseil exécutif la non-exécution sans avoir constaté par voie judiciaire la non-exécution. Quand j'étais à la Cour, l'expérience de la Cour, c'était que si l'État ne présentait pas son rapport sur l'exécution, ça a été considéré comme la non-exécution. Mais comme les règlements antérieurs des 2 institutions ont évolué, donc il faudra organiser des audiences publiques. Au moins, il y aura des échanges, des écritures entre les parties sur l'exécution. Et à la fin de ces échanges d'écriture, il faut une décision. Cette décision doit être une décision de non-exécution. Donc, la question serait, est-ce que les 2 institutions envisagent une procédure judiciaire de constatation de non-exécution ou pas? Merci beaucoup.
Thank you. Thank you for that question. Could I have a show of hands of those who would like to speak from the floor here? Okay, Sydney here, Chairman. Who else? Okay, Rachel online. So let's take those three questions here. Sydney, Chairman, and Zala. Yes. And then we go online. Let's begin with Sydney. 1 minute, please.
Thank you. I'll pick up from an observation Dr. Ayale mentioned, and then I'll direct the question to both him and Dr. Saj. This is the challenge of implementation at the national level, where you mentioned that there could be complications in terms of which agency of the government is responsible for implementation, perhaps which arm of the government is responsible for implementation, so that then the implementation is not just an sort of like an umbrella implementation on the state, but there are actual agencies and arms of government responsible for this. So now my question is, do the institutions recognize this, and are there structures in terms of their deliberations as well as the language of their decisions to address this, so that a decision is more calculated or curated to make it possible or make it easy for a state to implement? Thank you.
Hey, Chairman.
Thank you so much, Mr. Chair. So my question is directed to Ayalu. Sorry, I can't see you very well. So I'm taking interest in your presentation with respect to the working group on implementation. So clearly that aspect of your presentation suggests that the conversation we've had earlier on today is not completely alien to what is already happening at the committee. So it means that it's something that the commission should look at. Now, the question is, could you please enlighten us on the composition and terms of reference of this working group? Because I would like to get some ideas there in terms of developing my own, in terms of how it operates in reality. Thank you so much.
Thank you, Chairman. Over to you.
Thank you, Chair. My question is for, I'm just, if you remember, like you were mentioning about the digitalization of the systems. So can you just give me an example of which kind of system that are using, which are more specific, like which programs, so we can be able to see it and if we can be able to adapt it. Thank you.
Thank you. That's a question to Justice Aminu. Let's go online for the final question before I come back to the panelists.
Hi, Rachel, are you ready?
Yes, I'm ready. Can you hear me? Thank you so much. And I'm sorry I can't be there. My eldest daughter is about to go to university and I wanted to spend the last few days with her while she was at home. I just had one question to the chair of the commission, who mentioned this morning that there was a lower than 5% implementation rate. And I just wondered how that figure had been reached, particularly given the challenges that were also mentioned, that insufficient information was reaching the Commission on actually what states had done to implement. Thank you.
Thank you, Rachel, for that question. The chairperson has worked out to take an important call, but is ably represented here. So either Commissioner Lita or Abiola will take the question. Let's come back to the panelists. Climo, I don't know whether there was a question related to you. No? So we'll begin with Saj and then Ayelo, then Justice Aminu for your specific question directed to you.
Merci de me passer la parole pour apporter des clarifications sur les deux questions qui concernent ma présentation et certainement qui concernent aussi la présentation du collègue du comité. Monsieur Pedro a posé la question de savoir est-ce que les deux organes, y compris la Cour, envisagent une procédure judiciaire de la constatation de la non-exécution ou pas. Je crois que c'est... Voilà. Je vais me référer aux articles 80 et 81 du nouveau règlement intérieur de la Cour qui est entré en vigueur en septembre 2020 et qui consacre la possibilité pour la Cour d'organiser une audience de surveillance de l'exécution, des difficultés d'exécution de ces décisions. Parce que cet article dit que la Cour peut, en cas de différend sur l'exécution de ces décisions, organiser une audience de conformité. Ça veut dire que l'audience de conformité, c'est une procédure judiciaire. Ça veut dire que après l'arrêt, la Cour ne se limite plus au prononcé de son arrêt. C'est désormais un nouveau contentieux qui peut s'ouvrir devant la Cour, le contentieux de l'exécution de ces décisions en cas de différend. Cela signifie quoi dans la pratique? Dans la pratique, lorsque l'État soumet un rapport d'exécution, le rapport d'exécution est soumis également au requérant pour observation, parce que le requérant doit faire ses observations sur le rapport d'exécution soumis par l'État. Alors, lorsque nous communiquons le rapport d'observation au requérant, il doit répondre sur la conformité des mesures ordonnées dans l'arrêt. Il peut dire que, à travers son rapport d'observation, que l'État s'est conformé à l'intégralité des mesures ou encore l'État ne s'est pas conformé à l'intégralité des mesures parce que toutes ces mesures sont listées dans l'arrêt qui est prononcé au terme de l'examen de l'instruction de l'affaire. Alors, s'il y a 10 mesures, le requérant doit se prononcer sur les rapports cités par sur l'exécution des 10 mesures. Alors, il arrive que le requérant fasse une observation selon laquelle l'État ne s'est pas du tout conformé. Nous avons dans certains arrêts subi Gorée contre Côte d'Ivoire où le requérant a fait savoir que l'État ne s'était pas entièrement conformé. Alors, en ce moment, il y a un différend. Le différend naît de la contestation des mesures, de la non-acceptation des mesures estimées, des mesures prises. Alors, en ce moment, il y a un différend et la Cour doit apprécier. La Cour doit apprécier, c'est-à-dire la Cour doit déterminer effectivement le statut de la mise en œuvre. Cette détermination peut se faire lorsque cela est avéré par l'organisation d'une audience de conformité. Les parties doivent être convoquées, les parties doivent soumettre des écritures et la Cour doit entendre ces parties sur les aspects contestés. En ce moment, je peux vous dire que c'est l'exécution d'une procédure judiciaire de constatation. Alors, au terme de l'audience de conformité, la Cour doit se prononcer sur l'exécution ou pas. Et parmi les mesures que nous sommes en train de mettre en place, alors on peut se demander à l'État de nous soumettre un plan d'action sur les mesures inexécutées, dans un délai déterminé. Alors, l'État, si l'État peut le faire, si l'État ne le fait pas, on rendra une ordonnance supplémentaire, une décision supplémentaire qui constatera la non-exécution. Et alors, le rapport de la Cour figurera dans le rapport annuel qui sera soumis au Conseil, au Conseil exécutif. Qui, vous le savez, la Cour dans ses pratiques, chaque année soumet un rapport d'activité. Et le rapport d'exécution fait partie du rapport annuel d'activité de la Cour, parce que la Cour, chaque année, fait état des arrêts rendus, fait également état du niveau d'exécution, du taux d'exécution de ces arrêts. Donc, vous comprenez que pour répondre à votre question, il s'agit d'une procédure judiciaire qui est instituée par les règles 80 et 81 du règlement intérieur de la Cour. Mais aussi, qu'on vient de dire que toutes les demandes, toutes les requêtes ne peuvent ne pas faire l'objet d'une audience de conformité. Et dans ce cas, toutes ces affaires figureront toujours dans le rapport annuel de la Cour sur la partie consacrée à l'exécution de ces décisions. Maintenant, j'aimerais aborder le deuxième point sur le langage utilisé pour renforcer la mise en œuvre. Je crois que c'est la question que un participant a posée. Alors, il faut tout simplement, pour la Cour a mis en œuvre, ça faisait partie d'une recommandation de Dar es Salaam sur l'amélioration de la mise en œuvre des décisions de la Cour. Il se posait alors la question de la clarté et de la précision des arrêts ou mesures provisoires ou des mesures provisoires de la Cour. Donc, désormais, la Cour rend des arrêts plus clairs, les arrêts, parce que parfois, les requêtes en interprétation montrent que certaines dispositions ne sont pas claires. Parfois, les États font également usage des demandes, des requêtes en interprétation de certaines dispositions des arrêts. Et pour juguler ce phénomène qui pouvait également constituer un obstacle à la mise en œuvre des décisions de la Cour s'est résolue à rendre des arrêts plus clairs et plus précis. C'est-à-dire une politique qui consiste au moins, désormais d'ailleurs, la Cour ne prononce plus ses arrêts lors de la Cour, à une session, la Cour examine tous ces arrêts et prononce ces arrêts lors de la prochaine session. Or, par le passé, la Cour examinait ces arrêts et prononçait ces arrêts au cours de la même session. Maintenant, la pratique consiste à travailler, instruire, préparer ces arrêts au cours d'une session et prononcer ces arrêts au cours de la prochaine session. Ça permet à la Cour de mieux travailler ces arrêts, de rendre plus clairs ces arrêts et de rendre les mesures ordonnées plus précises pour faciliter la mise en œuvre. Parce que le point de départ de la mise en œuvre d'un arrêt, c'est lors de son instruction. Lorsque l'arrêt est clair, lorsque l'arrêt est bien rédigé, est plus précis, alors on aborde déjà un aspect qui va faciliter sa mise en œuvre lorsque la Cour rendra ses arrêts. Donc voilà, monsieur, les deux questions qui ont été posées. Je me suis évertué. Je pense que je vous ai.
Thank you, Saj. Ayalo, over to you.
Thank you very much, Dr. Jafet. Quickly, my brother Pedro, I think exactly similar procedure. So we report not only on non-implementation, but as part of the activity report, we report on implementation as well. So the reporting to the Executive Council and the implementation hearing are two separate processes. So for instance, in most of the cases, the implementation hearing happened 2 years after the decision of the committee on that particular communication. So when the decision is out, it will be reported to the Executive Council as part of the activity report of the committee, and it will form part of the decision of the Executive Council. And then when the hearing happens, the implementation hearing happens after 2 years, both the progress and the gap will then be reported as part of the activity report of the committee. So there are two different processes. And there are separate guidelines on implementation hearing within the committee. I hope I have answered the question. Otherwise, we can continue the discussion. Second question, my brother here. Yes, that has been identified by the committee, for instance. That's why the committee has been pushing for establishment of national mechanisms on reporting and follow-up. And it's not completely alien. There are countries which have already established, and this would be of your interest as academic engagement as well. There are countries which have already established those mechanisms. Like, for instance, I'm not sure about Malawi, but I know Malawi as well, right? If Niger, Botswana, Mauritania, no, Mauritius, sorry, Morocco, they have established what they call national mechanisms on reporting and follow-up. In Botswana, I stand to be corrected, there was an interministerial committee, which was established to follow up on reporting and follow up on state party reports as well. So these kind of bodies can actually play a great role in coordinating implementation of decisions of these regional and continental bodies. So the committee has been pushing for that one. The second, it can be a permanent structure, but it can also be an ad hoc structure. There are experiences where countries have actually established task forces, interministerial committees, to actually follow up on specific decisions. Third, the committee also has been encouraging, when it comes to its own decisions, for instance, the line ministries, in the absence of interministerial committees or task forces or national mechanisms on reporting and follow-up, the line ministries to take the responsibility of coordinating and following up on implementation of its decisions. So usually the line ministries, where the matters related to children's rights lies, will then take the responsibility of coordinating. Otherwise, it would be very important, first of all, in your decision to identify which authority or which agency within the government or which branch of the government even to implement which decision of the commission or the committee. So because it might lie within even beyond the executive organ, it might go to the parliament and all those things. So understanding that complexity would be very, very much important, but also encouraging governments to establish this kind of bodies at preferably permanently, but also in ad hoc basis. That would be a good solution. Chairman, your question on the composition and TOR of the working group. It is available, the TOR of the working group on implementation of decisions, but also the other working groups as part of the special mechanisms within the committee. It is available on the website of the committee, but there are 4 members of the committee. Unfortunately, this working group does not have external experts as part of its composition. This is something which can be recommended to the committee from stakeholders like yourselves. The other working groups, like working groups on disability, climate change, and business, they have external experts as part of their composition. But unfortunately, the working group on implementation of decision is left only for the members of the committee. It meets twice a year, preceding the week of the session of the committee, and its activities and TORs are established through resolution, which is available on the website of the committee. Thank you very much.
Thank you so much, Ayolo. I'll go to the commission. I don't know whether there's someone to speak, Abiola. Before we go to Justice Amini, she has a small presentation she wants to make to demonstrate the digital platform that she was speaking about. Abiola. Yeah.
Thank you very much, Dr. Japheth. I believe that the chair was referring to, you recall that we had presentations where there were references to statistics, for instance, the study by Dr. Leret Lu, Professor Villon, and a few other studies. So I guess it was a general reference to the estimated level of implementation, because we've been very explicit on our side that we don't have data. This is something that we are working on. Yes, and we would take the presentation on behalf of the chairperson and my colleague. Zelalem is here to take in the details because it's most relevant to his portfolio. Thank you.
Thank you. I hope, Rachel, you've got that clarification. The chairperson was referring to the statistics from the France and Leroy.
Commissioner Letha would like to say something.
Oh, okay. Okay, Commissioner Letha.
Yeah, I think there's a question which came from one of the participants online on 5% implementation. And I think it's good to just say something about that question. Considering that poor reporting is one of the contributors to us not knowing exactly what has been implemented or not. I think the biggest problem we have is a budgetary one. And from my past experience, if you write 2 proposals, one to finance activities that have been planned, that is implementation, and one to monitor the implementation of those plans. You will get resources for monitoring, implementation. You'll get 0 resources for actual implementation. So from that, what we have to now ask ourselves is who is responsible for implementation? Where does the money come from? And it boils down to the member states. So if member states have to mobilize resources to implement all these activities, then why do they need us? Member states don't need AU, member states don't need our organs, they don't need the UN, if they actually are the ones to eventually implement the same activities we keep on recommending. So I think there are 2 things I would like to say here as my contribution. What is expected of us as African Union organs is to come up with ideas, edge-cutting ideas that member states can be able to use to unleash finances, to be able to implement all these recommendations in Agenda 2063. Even when we sit here, we're going to come up with recommendations. So that is what I think we need to do. We have set up institutions that are supposed to come up with some of these ideas. But even them, I see them in the AU budget. You know, I'm sorry to say this, but institutions like the African Union Development Agency, NEPAD, which was created to help us mobilize resources, not traditionally, but, you know, edge-cutting ideas. Their budget goes to the AU, they want money also for implementation. So really, I think we need to have a change of mindset and a serious paradigm shift when it comes to implementation. I do not think our problem will be monitoring implementation. Our problem will be actually raising resources for implementation. And in my research, I think there are a few ideas that I can share here with you. And one of them is looking for finances where money is actually sitting. I think diaspora is one of the areas where we could tap resources from if we are organized for implementation. Pension funds, we've talked about our pension funds for many years. Our countries sent money to France. I don't want to go to the tips, but I want to say that in insurance and in pension fund management, a lot of resources sit there. And some of the money that we contribute into those pension funds, which is our money, can be used for implementation. Value addition. We have resources, but we let our resources go, be exported without being adding value. And so we export our own resources. So we need to look at our resources. We have minerals, we have wealth, we have oil, but what happens to that? We export it without value addition. So we are actually exporting our own resources. illicit financial flows. Money is leaving our continent more than it is coming in. I think this conversation is about human rights implementation of our own agenda. But I think to actually deal with implementation, you have to think out of the box. You have to think differently, because that is where the 95% of implementation will come from. So that is what I just wanted to add into this conversation. From a political point of view, I thank you.
Thank you, Commissioner Lita, for those reflections. Justice Amin, we will come to you now.
Good afternoon. The question from the data analyst. Please, can you repeat your question, if you don't mind?
If you can show us a little bit demonstration how it works, how you is the case management.
Okay. What I did in my own court in Nigeria, because I was transferred to the northeastern part of the country, where there's Boko Haram insurgency. So I realized that there's so many things not working, no correctional center in the state capital to bring in inmates to court. There were so many challenges. So I decided to incorporate the digital, the whole concept of digitalizing the court, so that it can enable me to still work. If not, since inmates are not being brought to court, we'll only do civil cases. And as the Federal High Court, usually most of our cases are criminal, terrorism, narcotics, currency, all those cases. So what I did, I got a software developer to assist me. And I told him what I wanted, since I do not have a background knowledge of software applications. So in my court, what we do is he developed what I wanted to show you now. As you can see, when you click on the software, it brings out, because presently in the whole country, we have about 80 judges or thereabouts. None of them are doing that. I'm the only person doing it. So you bring in the court, then I log in, then log in successful. From here, it gives you, this is just for the judge. Meanwhile, there is another platform for counsel. There's another platform for the court registrars. So all information, all processes, whenever you need them, all you need is a click to enable you get the process because it's online. So all the processes, because all counsel need to register on that platform. So a counsel can attend counsel from one chamber or from the Ministry of Justice, from everywhere. So they can register their processes without coming to the court, and then which will enable me have a preview of what to expect when I go to court. Usually they pay, they do everything online, the e-payments, the e-filing, e-hearing notice application, as well as the, like I stated earlier, virtual procedures, which enabled me to see the inmates in court in the correctional center. So from here, we have new cases for assignment. You can see new cases because presently the Federal High Court is on vacation. So the moment I resume, those are the cases I have. So in essence, what I'm saying, everything is in one place. You don't need to go anywhere to look for any document. And as long as you have registered on the portal of the Federal High Court, you can access your documents anytime. You don't need to start looking for, if you have a similar case, you don't have to start looking for documents, such similar documents. So most counsel that appear in my court throughout the country are pleased with that. And then for me, like I stated earlier, it enables me to have a preview before the case, the file is brought to me physically. I do see it, but for that, I still collaborate with the software developer. I pay him personally, just like whenever we have proceedings, I pay for the data for the Zoom meeting I have with the correctional center. And I do not know whether I've answered your question, or if you have any more.
No, it's okay. It's good. Thank you. Thank you.
You're sure?
Thank you.
Yeah.
Yeah, can you for us?
It's exactly 1 minute past our appointed time, unless there is a very, very burning comment or question. Deborah and Pacharo, you've been mentioned since morning. I wonder whether you are reserving your presentation for tomorrow, but it will be good if you give us a preview now that you've been mentioned multiple times.
Okay, thank you so much. And once again, I want to join those who've spoken to congratulate the presenters for very good, insightful, and very enriching presentations. Malawi has been mentioned, especially on the ACHPR case. I will spend more time tomorrow to explain, but just a little. I think the case highlights typically that for us to have the decisions, whether of the commission or the committee or the court, to be implemented properly, and for us to have impact of these decisions, there's need for what I would call a coalition of like-minded human rights people in the executive, in the judiciary, in the national human rights institutions, as well as in the civil society. I think that case demonstrates how all these branches worked together with the committee to ensure that we had a positive outcome. So that's what I would say now. What we need is a coalition of human rights minded people to work together in different arms of government. Thank you.
Thank you, Pacharo. That's just a preview of the presentation tomorrow. Deborah, you have the final word.
Thank you. I think I'm very blessed to be the final person to take the floor. And basically, my question is directed to all organs, first starting with the court. The presenter talked about establishing national focal points to follow up on the implementation. And I wanted to inquire whether the presenter foresees a role for national human rights institutions in following up on implementation. Secondly, is to Dr. Ayello. I think we've worked together very well to move from 0 NHRIs with affiliate status to now 20 NHRIs with affiliate status before the African Committee of Experts on the Rights and Welfare of the Child. And I would just like to inquire if the committee has engaged NHRIs on the question of implementation, particularly in your country visits. For the Pan-African Parliament, I don't think we have an existing collaboration yet, but maybe to ask if you foresee any role for the national human rights institutions, and for the respondent being the African Commission on Human and People's Rights, where we've had a standing relationship since the 1998 resolution on granting affiliate status to NHRIs, and very progressive provisions under the 2020 rules of procedure, including, for instance, transmitting the activity report as well as decisions of the Commission to the NHRIs, maybe to inquire if the African Commission has been able to directly transmit these decisions and activity reports to NHRIs, and whether there have been any challenges or best practices coming out of that engagement. So thank you very much for the floor.
Thank you so much, Deborah. Clement, I think your final remarks, though no question has been directed to you, but I think 1 minute in final remarks, your reflections.
Thank you very much, Mr. Chair. I would just thank, first of all, our colleague for the question, but also thank one of the participants who sent me a direct question by email, and to which I've just responded, to say that NHRIs at PAP, yeah, they seem to be absent, and I think it's, but the framework of the Pan-African Parliament gives room to every possible institution, whether governmental or non-governmental, to engage with members of parliament, where they can trigger even motions through members of parliament, where they can appear before a specific committee, permanent committee. And I'm particularly looking at the possibility of appearing to brief or to trigger any action before the Committee on Human Rights, Justice and Human Rights, and through this committee then trigger a specific action at the plenary, whether it is a resolution or a recommendation on a specific issue, whether it is human rights or any other shared value. Yeah, so that's my answer.
Thank you, Saj. 1 minute. We have less than 5 minutes to wrap this up.
Thank you. Oui, à la question de savoir est-ce que la Cour envisage les relations aussi avec les INDH, je dirais que au-delà de l'établissement des points focaux par les États envisagés par la Cour, et un des outils mis en avant par la Cour parmi ses priorités pour l'amélioration de la mise en œuvre de ces décisions, il convient de dire que le règlement intérieur de la Cour africaine des droits de l'homme et des peuples, notamment sa règle 80, prévoit que la Cour peut recevoir peut chercher des informations sur la mise en œuvre auprès des autres sources crédibles. Ça veut dire que lorsque l'État soumet un rapport d'exécution ou ne soumet pas, la Cour peut également obtenir des informations auprès d'autres sources crédibles. Et ces sources crédibles sont les institutions nationales des droits de l'homme établies au sein des États. Donc, cela signifie que cette coopération avec les INDH est également consacrée dans notre règlement intérieur, parce que nous pouvons faire recours aux INDH pour collecter les informations en vue de confirmer ou non l'exécution, la mise en œuvre des mesures ordonnées. Donc, c'est pour vous dire que la coopération avec les institutions nationales des droits de l'homme est consacrée. Elle figure dans nos mécanismes de coopération avec les autres acteurs qui sont en dehors des États. J'aimerais, s'il vous plaît, me permettre d'apporter quelques précisions sur la contribution de la digitalisation de la base des données sur le suivi de l'exécution. Je dirais que la base des données est un outil fondamental. La digitalisation est un outil fondamental d'amélioration du suivi. Parce que lorsque nous faisons intervenir les autres parties prenantes. Ces autres parties prenantes doivent être au parfum des informations. Parce que le plus souvent, nous avons eu des demandes des requérants qui veulent avoir l'information sur la mise en œuvre de leurs décisions. Or, à partir de la disponibilité des données, des éléments dans le site web, le requérant ne peut pas souffrir pour avoir les éléments pour assurer le suivi. Il lui suffit de consulter le site web de l'organisation et de regarder les statistiques pour se rendre compte du niveau d'évolution de la mise en œuvre de son arrêt. Et par conséquent, cela peut inciter la poursuite d'une autre action. Donc, la base de données, la digitalisation est un élément fondamental dans le processus de suivi et de mise en œuvre des décisions judiciaires. J'apportais tout juste ma contribution pour la question que vous avez posée tout à l'heure sur l'intervention de l'honorable juge. Merci.
Thank you, Foluso. Your announcement quickly before we move to Ayalo.
Okay, just before my announcement, I would just like to say, Chair, that please we need to leave as soon as possible. I know these are burning issues, but we will definitely take this conversation beyond this room. So please, we just need to stick to time because it affects other activities. So my announcement is just to clarify for the presenters for the paper publication that the deadline is actually 31st of October, not September. So just to clarify, I think there was a bit of misunderstanding in the morning. Thank you.
Ayalo?
Thank you, Dr. Javid. Yes, Deborah, the committee has been engaging. I didn't mention about the NHRIs and CSOs. I think we have a session where we're going to discuss that. But as you've said, the committee has now 20 NHRIs with affiliate status before it. So even before the affiliate status procedure was established within the committee, as part of our advocacy missions, follow-up missions, fact-finding missions, we normally engage national human rights institutions. And in all the follow-up missions with regard to implementation of decisions, the committee visits the respective NHRIs on the ground, and that will also be reflected in the final outcome of the missions that the committee undertakes. Thank you very much.
Thank you. Deborah's question also was targeted to the African Commission, but we'll pack it and answer it tomorrow when Deborah makes her presentation. Join me, please, to thank you, my panelists, for well-presented presentations, and thank you so much.
Thank you so much to our panelists for that very engaging discussion. Just a quick announcement. You will have noticed in our program that we are set to have a gala dinner, which is scheduled for 6 o'clock. There's just been a slight amendment. We will now be meeting at 6:30, and we will be meeting in this venue. So we do hope to see you here at 6:30 so we can just unwind a little bit tonight and hopefully continue some of our engaging discussions from today. So for now, I hope you get some time to relax and prepare for our gala dinner later. And please, if we could try to just get out of the venue as quick as possible so that the necessary preparations can be made. Thank you all so much.